Okay.
I'm thinking there's a restitution because the property was recovered. I do think she got things that didn't get recovered as a part of this.
Okay.
I'm seeking 60 months probation.
Okay.
And she has an open charge of humanity for the same thing. And this probably violated her bond there.
Okay.
But just given how to
Yeah.
and I know that Judge Helen doesn't like to give time for why we should jail.
Yeah, she just won't.
And she's only 20 points.
Okay.
So that's why I'm seeking as much probation as possible.
Okay. All right.
Oh, yeah. One break and then.
She's out, right?
She does.
Oh, she is? Okay. Kevin, I was wrong. She's the last lady. The higher you go. I think she got picked up again.
I'll go get it.
You didn't make a calendar.
Hey, Mike. Hey, I saw that you called.
It was the last day out on me.
Yeah. I figured that's what
Yeah, like, I found out last night. She just found out. Nope, here. Ross, do you want any?
And where she at? I think we're gonna have to. She's got something going on. She's been busy
All right.
this week. I don't know.
Circuit Court in Pinellas County is now in session with Honorable Chris Heller, Circuit Court Deputy.
Good morning, you can all be seated. Good morning. What do you have today?
With Mr. Brooks, there was an add-on that he added Diamond Edwards.
Okay.
And it appears she was not brought over from the jail, so I think we're just continuing it.
Okay. You're going to have to call me in.
And get it reset on another day?
Well, yeah, whatever day doesn't already have 5.
I understand.
All right, thank you.
All right, thank you.
Morning, Mr. O'Hare.
Good morning, Your Honor. I'm here off calendar, Your Honor, on Kevin Vines, 17-13932. It's set for trial next Wednesday, and I believe Ms. Emus came in and informed the court that it wasn't going to be a trial. We have something going on in that. I wasn't here last week, and she said she was going to come in. I thought she was going to be here this morning, but...
Well, why can't it be tried? I don't remember her, but...
Well, I'd have to approach on that, Your Honor.
Okay, is it the obvious answer?
No.
Oh.
Mr. Vines was approached by an inmate.
Oh, yeah.
And that's come to fruition in charge. Mr. Vines is going to get a deal, so we don't.
Hello, Mr. Dikai.
Hello.
What do you have? Something about Townsend?
I don't have, I was looking for Mr. Eilers to talk to.
He just went
Okay.
to get something.
Okay.
I'm going to pass that.
I'm going to ask for something different.
What are you going to ask for?
I'm going to ask that we just reschedule it.
Why would I do that?
Well, I'll give me, I can explain.
Okay.
Can I come a little closer? I don't want to.
Yeah, but you can't. I mean, is there some reason it has to be private?
It concerns a family member of mine who's in the hospital.
Come on.
Can we just wait a minute for Mr. Eiler?
Raymond James.
Yeah, Shona, he's ready to be brought up.
Okay.
Thank you.
There's not? Nothing? For either of the cases?
I'll find out in a minute.
Isn't there a departure date? There's not, it's not for departure?
No, it was settled the 22nd, it was canceled.
I'll set it for a pre-trial April 15th. Good morning, Mr. James.
Morning.
This is 2 counts of possession of controlled substance. It's 2 spice joints that just tested positive for different substances. We are asking if the court would accept. He scores non
Jonchuck. Send him back, Jonchuck.
Olive, pulling back. Yeah.
So you're on to me, but I'm marking you the dissent in this case from the day.
This is the sitting in on the witness expert sitting.
Oh, this is the Strausser, yeah.
Yeah. Are we ready for Mr. Jonchuck? Thank you.
I mean, hard.
I've got that ready. Yeah. You want me to make your copy of that apartment?
Yes. Two copies, would you?
Sure.
That'll be for the next one.
So now,
Yes, please.
5 minutes ago.
Yes.
You got it.
Maybe like 15.
Oh, yeah, I know. I can just see that, you know, or we could get there with some gas. Maybe up there. That's cool. Something comes up. I'm sure this is a piece. So.
Morning, Mr. Jonchuck.
Good morning, Mr. Jonchuck. were obviously gone by the time we were out of court yesterday, so we're working on
Okay.
coordinating things.
Folks, make sure you check your cell phones, electronic devices, make sure they're off and put away.
Okay, are you ready to discuss the issue about the state's mental health expert sitting in the trial goes on?
Yes, sir.
Okay, Mr. Ellis, I've read all of them, I've skimmed through. The first one and then the Hernandez case. Come on.
Judge, under 90.616, subsection 2C, that's the exclusion of witnesses. The court can order sequestration except where a witness may not be excluded if their presence is essential to presentation of the party's cause. And under 90.704, facts or data upon which an expert bases an opinion or inference may be perceived by or made known to the expert at trial or before trial. And I have 4 cases to cite. The first one would be Hilton. That's 117 Southern 3rd, 742 from March of 2013. It's a Florida Supreme Court case. Basically, sequestration, as the court's well aware, is to prevent coloring of witnesses' testimony. Well, experts rely on other witnesses' testimony to help form their opinions. In that case, the state expert was allowed to sit through the penalty phase of a murder and give notes to state attorneys and assistant state attorneys, and the court, Supreme Court found that the court did not abuse its discretion in allowing this.
Can I just ask you some questions about that case? It's under footnote 9, it talks about The state was late filing its notice of intent to seek the death penalty, which prevented the expert from examining the defendant. I don't think that's true in this case, is it?
No, Judge.
Okay, and it was necessary for the expert to be excluded to give him a chance to provide meaningful assistance to the state, which I guess he couldn't do because the death penalty notice was late. And in other words, your experts have had plenty of time, correct, to do whatever they were going to do?
Yes, Judge.
Okay. Witness sequestration rule allows an exception when a witness's presence is shown by the party's attorney to be essential to the presentation of the party's cause. How would you respond to the fact that the presence is essential?
Several different issues, Judge. As if the defendant testifies, I would think that would be essential for the state. There's a case that we have that would say that that would make it essential for the experts to provide us information regarding cross-examination of the defendant and their evaluation of the defendant. Also, I think they are essential when the other experts testify to help provide us information in areas of cross and evaluating the testimony of the experts. As to the civilians, I think that is a situation, Judge, where the experts are allowed to testify as to what occurs at trial. I'm not sure it's quite as essential as it would be for an expert, except for Attorney Torres, who was slightly before trial. They waived her attorney-client privilege, and our experts have not had the opportunity to read in depositions of her or have contact with her. So we would ask that that would be an essential situation too. So we believe that the defendant testifies is essential, Torres is essential, their experts are essential, and I believe that the court, within its discretion, could allow the experts to sit through the testimony of the civilian witnesses called in after the first part of this trial, the state's factual part of the case.
Okay, so let's go on. Were you going to go through any other cases?
Yes, Judge, briefly. On Hernandez, that was another case where the state's expert in the penalty phase was allowed to testify, not to rebut factual witnesses, but to assist the state and to testify regarding issues for the state at that point. And that, Hernandez is 4 Southern 3rd, 642, Supreme Court case from 2009. There's the Knight case, 746 Southern 2nd, 423 from 1998. That is also a Supreme Court case. In that case, the detective was allowed to sit through an entire resentencing. The court indicated that the purpose of sequestration is to prevent or discourage fabrication, inaccuracy, or collusion, and to avoid coloring the testimony. Having the state's experts sit through the testimony of these witnesses would not be a situation where we would have fabrication, inaccuracy, or collusion, or coloring their testimony, which is the whole reason for sequestration. In that case, the officer was allowed to testify because it was a couple of decades had passed since the original case, and he was allowed to testify regarding resentencing and subject to cross-examination. And last was Strausser, S-T-R-A-U-S-S-E-R, 682 Southern 2nd, 539, a Supreme Court case from October of 1996. And that is a court-appointed doctor was allowed to sit through the defendant's testimony at trial. They considered that not an abuse of discretion. So that's why I brought up the defendant testifying. If he does, our experts should be allowed to be there and be present for that. Even though they've had a chance to interview him, I believe it would be important for them to do so. So I would think it's essential for the Torres, the defendant, and the experts, and I think it would be within the court's discretion to allow for the rest of the witnesses. And the reason rules for sequestration really wouldn't apply when they're like it's normal witnesses, because that's what experts do. They rely on the testimony of others.
Okay, and I'm looking at the Hernandez case, and I'm on head note 23 on the top of page 4.
Yes.
And it says, only experts' professional opinions differed from those of defense witnesses, and there was no suggestion that either his opinion or his factual predicates upon which these opinions were based would have been different if he had not been allowed direct access to other testimony elicited during penalty phase. if I'm not mistaken, yesterday you said at the bench that one of the reasons for doing this was to see if an expert's opinion was different after listening to these witnesses, right?
So that could occur, yes, Judge. In that case, it says that in that particular case, there was no suggestion that his opinions had changed. It doesn't say that it can't be done so his opinions don't change or won't change. It just said in that particular case, his opinions didn't change. That's what, if you look on page 19 of the handout. He did not refute, it says, in sum, Dr. McLaren did not refute the factual testimony of other witnesses during the penalty phase and admitted that he observed the testimony of other witnesses during the penalty phase. Only his professional opinion differed from those of the defense expert witnesses. Further, there is no suggestion that either his opinion or the factual predicates upon which those opinions were based would have been different if he had not been allowed direct access to the other testimony listed during the penalty phase.
Yeah, but in this case, that's part of the consideration that you are considering and asking me to do that, right?
Well, it could occur. I think we have to take that is something that could occur, yes.
But that's part of the reason for you wanting to do this.
Yes, Judge, and to, again, with the essential witnesses to provide us information, and obviously we're not trained in psychiatry and psychology, and I think that we are allowed to have those experts assist us in our cross-examination of those witnesses, and the defendant and Torres, and then we're asking for use of court's discretion for the other witnesses, and also, Judge, this applies to the defense. This is not a one-way street. They're experts to do the same thing.
Well, they haven't asked me to do that.
But if you ruled, it would obviously allow them to do it.
Yeah, obviously.
Right. And I know they haven't asked for it, but I'm not asking for something that is only one-sided.
Well, I think it is, because you're the only one asking for it.
Well, if they chose not to do it, that's a decision they make.
The burden is on you, though, because you're asking me to do it. Isn't that correct?
Correct. I believe we presented why we believe that they are essential, and those witnesses we think they're essential to, and why we're asking you to use your discretion on the other witnesses.
Well, this last one, Strausser, is the defendant. Okay, this is, and whoever from the defense wants to address this.
Yes, Your Honor.
Okay.
I think several of the questions that the court had for Mr. Ellis are really what I would like to argue, but I think it's important to go back and look at what the purpose of the sequestration rule was at common law. And the cases that I have for the court are the same ones provided by the state. I mean, they're the same thing. So in looking at the Hernandez case from the Florida Supreme Court in 2009, in referencing a U.S. Supreme Court case from 1976, they talk about the dual purpose of the rule of sequestration, that being that the rule exercises a restraint on the witnesses from tailoring their testimony to that of earlier witnesses, and the rule of sequestration aids in detecting testimony that is less than candid. The Florida Supreme Court also talked about the purpose of the rule of sequestration in 1998. This is also cited in the Hernandez case, when they say the purpose is to avoid a witness coloring his or her testimony by hearing the testimony of another, thereby discouraging fabrication, inaccuracy, and collusion. At common law, as we know, making an exception to the rule of sequestration was discretionary with the court. The Hernandez case talks about Burns v. State, which is at 609 Southern 2nd, 600, Florida Supreme Court from 1992. And in that case, it was found to not be an abuse of discretion for the state expert to be present during the entire penalty phase of a capital trial, including the fact witnesses, when the defendant had not been required to submit to an examination by the state's expert. And sitting in on the testimony was the only avenue available for the state's expert to then be able to offer meaningful expert testimony and to rebut the defense's mental mitigation evidence. That is certainly contrasted from the situation we have here, where the state has had access to Mr. Jonchuck for multiple days of evaluations by their experts. They've had access to all of the records, all of the depositions, all of the collateral sources. So this is absolutely not a situation, as existed in Burns, where the only way for the state to rebut the evidence is to have their experts sit in. Of course, the rule of sequestration was codified in 1990 and made the sequestration be when it was discretionary at common law. The rule made it demandable by a party when it was codified. At the request of the party, the court shall order the witnesses excluded, of course subject to the exception that we are talking about. The exception being if the presence of the expert is essential to the presentation of the state's case. And I would like to respond to a couple of the state's arguments on that. Of course, the burden is on the state to prove that breaking the rule of sequestration is essential to their case. They talked about if Mr. Jonchuck testifies that they should be allowed to sit in. I would say that would be a bridge to cross if and when we get there. When other experts testify, of course, we know that that is commonly an exception to sit in on the other experts. As to the other civilian witnesses, the state and their experts have had access to all of the witnesses since the beginning of 2015. They have done interviews, collateral interviews. They have had access to the deposition transcripts and all the reports, and could call and find out what these people have to say at any time. The state did argue yesterday and said here again this morning, well, what if a witness says something that is different and it changes the opinion? I think that that's a matter to be handled on cross-examination. A trial is not supposed to be where we're finding out in the middle of trial, both sides, that an expert is changing their opinion. If something changes in an expert's opinion under Rule of Criminal Procedure 3.220, the state has to put us on notice of that. They have to tell us that. It is not to be trial by ambush where we're finding this out in the middle of testimony. So they've had access to all of the witnesses. The state specifically spoke about witness Genevieve Torres and argued that it is only just before trial that they have the privileges waived, and so they had access to her, and that is just not accurate. The state had access to her at Invest and was able to interview her, and I believe did interview her. I don't believe, they did interview her. The privilege was not waived just before trial. We filed notice of the attorney's records, her file, in September of last year. I believe, if my count is right, was some 7 months ago. So this is not a surprise that we've just now waived privilege and that they somehow need access to the information. She's been available, privilege has been waived for months. So we're not doing something to surprise them at the last second. The case that the state cited of Strasser, which is also talked about in the Hernandez case, is in contrast, factually, from our situation. That arose only when, well, at this point, as I said, if Mr. Jonchuck decides to testify, I think that's something that could be addressed if we ever need to get to that point. But that's what the Strasser case was about. In that case, the Supreme Court ruled that it was not an abuse of discretion to make the exception to the rule and allow the expert to sit in when it was the insanity defense and the defendant testified. And the expert was only allowed to sit in for direct examination. So we're not anywhere close to where we need to be to come to the factual circumstances of Strasser at this point. So I would suggest that although an abuse of discretion was not found in that case is very much distinguishable. And I won't belabor the point of Hilton v. State because the court pointed out in that case the exception was made because of the state's late notice of the filing of the notice of intent to seek the death penalty under the rules that govern that. The state's expert was not allowed to examine the defendant. And so the only way to rebut that testimony presented by the defense was to make the exception and break the rule of sequestration. Again, that is distinguishable from our case completely because they've had all the access to Mr. Jonchuck over the last 2 years and have done all their interviews and evaluations. So at the conclusion of Hernandez, what we have, and I wanted to distinguish the Knight case that the state brought up. I mean, this is again a very factually different scenario than what we have here. In this case, the detective who was allowed to sit in through the course of the proceedings, this is under headnotes 4 and 5, the detective was a fact witness and he was testifying as to what others had testified to 2 decades earlier, or as to what they had said in the sworn statements. He was therefore, in a sense, a reporter of what other individuals had long since said under oath in a recorded statement, and his testimony was subject to being carefully checked by comparison to the transcripts of the trial testimony. So, completely different factual scenario. The detective was there to read into the record and testify as to the previous statements, not to listen in and look for inconsistencies in testimony by lay witnesses and then be able to change an opinion or do whatever else they might do upon hearing that information. So I would suggest that Knight is completely not on point and should not be regarded. Going back to Hernandez, the court said in assessing the error in allowing the expert to stand in, it was not prejudicial because the state expert did not refute any of the factual allegations of the lay witnesses, which the state has already said they might want to do. The expert did not dispute the defendant's history, his, of substance abuse, and the state's expert testimony correlated with the other experts regarding diagnosis and other things. That was not in dispute, and as we know in this case, that is in dispute. The expert in Hernandez was not basing his opinions on other experts' opinions, and the only difference that he was testifying to in that case was the absence, in his opinion, of the statutory mitigators, whereas defense experts said statutory mitigators exist. What we learned from Hernandez is that faced with or provided the same information, the state's expert simply said, no, I don't think they do exist. So it wasn't a factual dispute, it was an opinion dispute, which is what we have here. So the state has repeatedly said that they're asking for this so that the experts can listen for factual differences and adjust their opinion accordingly. And I would suggest that none of the case law presented gives the court authority for that situation. In fact, any time that we have seen in these cases the state expert be allowed to sit in without an abuse of discretion is an entirely different factual situation than we have here. So we would ask that they not be allowed to sit in for the lay witness testimony.
Okay, Mr. Ellis, do you agree that the attorney-client privilege with Attorney Torres was waived September 2018?
No, Judge.
Okay.
And that was part of the problem. Even Attorney Torres didn't believe that. She wasn't, when we interviewed her originally, we were not allowed to go into a lot of what was said because she brought her attorney with her and then she claimed attorney-client privilege. She was still claiming that even though when she revealed the client file, she was waiting for the defense to formally file a written waiver. They never did so. It wasn't until very recently that we were able to go talk to her at her office that she finally felt that that was enough of a waiver. But she was still, in her mind, asserting the privilege until just very recently because the defense never filed a written waiver of the attorney-client privilege. So I disagree that it occurred in September. They did reveal their file, but according to Ms. Torres, that was a gray area in her opinion, and she did not feel that it was sufficient to grant us the ability to talk to her.
Okay, well, so how, was there ever a written waiver of attorney-client privilege?
Not that I'm aware of.
And then how did, when you say, when did you finally talk to her? Did you depose her or just talk to her?
It was a couple weeks ago, Your Honor.
A couple of weeks ago?
Yes, we went to her office and we said, can we talk to you about this case? And she goes, well, at this point, I feel that we've reached that level that it is a waiver. So she made a decision at that point to allow us to talk to her about what occurred during the attorney-client meeting.
Do you know why she came to that opinion, that suddenly it was waived when it wasn't before?
Well, I can also add that I spoke with the defense, and they agreed, as we were discussing some pretrial issues just before the trial began, that was a waiver, but that was a recent conversation with the defense. And so that was also something that we discussed with Ms. Torres, that they believe that there has been a waiver.
Did you take a depo or just talk to her?
Just talk to her.
Okay, and did you supply the essence of that conversation to your mental health experts?
No, Judge, we haven't had that opportunity because we didn't have anything in writing or recorded or anything provided. We did not do that.
Okay. Do you disagree with anything Mr. Ellis has said about the availability of the waiver?
Well, we believe it was waived in September. I can't control what Ms. Torres's mind is, but we disclosed the entire file in September. Why, and if her position, Ms. Torres's position, or the state's position is that we were waiting for them to file something that said it was waived, like I guess that they're saying a piece of paper signed by Mr. Jonchuck.
Right.
We've never filed one, so without that being filed, she felt free to talk to the state and disclose everything 2 weeks ago, so I don't know what's changed. It was waived when we disclosed the file.
Well, I guess I'm trying to figure out what initiated the visit to her a couple of weeks ago. I mean, I understand why you're under the understanding that it's not waived, there's no, and why she's saying that too, but then that's what I don't get.
Well, Mr. Boland spoke with the defense. They indicated that was considered a waiver by them. We told her of that, and then she felt more comfortable in considering that a waiver as well.
Okay.
That's all I can tell the court.
All right, but
she was the one making those legal decisions. We had to allow.
Right, obviously. So after you got the file in September, her position was still, that's not a waiver.
She felt it was gray area and didn't feel comfortable as being a full waiver, correct?
Okay, and somebody contacted her from the state after that and said, okay, we're ready to depose you or whatever, and she said, not so much.
Correct, we want to come talk to you. This is what the defense has told us, and we went and talked to her a couple weeks ago.
Okay, so pursuant to this, I am going to deny the state's motion to have their experts present during any testimony except that of Attorney Flores, and if the defendant if the defendant testifies as Ms. O'Neill says, we'll deal with it then. When you look at her, I understand that it's discretionary. However, when you look at these cases, I don't see anything that is similar to what you're asking me to do. And when you look at Hernandez, that's the case where the opinion of the expert did not change. However, in this case, I believe part of the state's goal is to see if one of their experts' testimony would change based upon what is said in the courtroom, which is, I think, different than the spirit behind Hernandez. When you look at Strausser, that's really clear. We've talked about that ad nauseum. And that was just the expert being present in the courtroom while the defendant testified. So that's not what we have here. Knight is the detective in the resentencing, which he's basically a fact witness looking at the prior testimony. That's really different than what we have here. And we have Hilton v. State, 117 Southern 3rd, 742. And that's where there was a late notice for the death penalty. And the only reason, the only way the state could have access to the medical experts and the defendant, except from exam, was to be in the courtroom, apparently, where the expert listened to the defendant. So it seems to be most of these cases talk about some late development where the state's expert was unable to get the information from a witness and had to sit in the courtroom. And nobody has suggested that's the case here, other than Attorney Torres's testimony and perhaps the defendant. And additionally, and this is not why I'm ruling this way, it would raise another issue that would increase the length of the trial, and that is, if the expert's testimony changed, then the defense probably would be entitled to do an entire new deposition. But it's not why I'm making the decision, but that would also be a drawback of the decision. So the state can have their experts sit in for Torres and the defendant.
Not other experts, just because.
Oh, the other expert, for sure.
Oh, you didn't say that, that's why I
Oh,
wanted to
yeah,
clear
well,
that
that's a
up.
given.
Okay, well, I didn't take anything as a given, so I wanted to make sure.
That's a given. Okay, are we ready to start?
Yes.
Okay, let's bring in the jury, please.
Can we approach real quick, Judge?
Sure.
As soon as you get in line, bring them in.
Oh, hold on just a minute. I gotta ask Mr. Jonchuck about this stipulation. Okay? Mr. Jonchuck, you don't have to stand up, sir. However, I need to ask you about this stipulation, okay? Your lawyers and the state have stipulated that the medical examiner can testify that the dead person is Phoebe Jonchuck, your daughter. Without that stipulation, they would have to present a witness who would have to identify her as, that would have identified her as Phoebe Jonchuck, or somebody I guess now, that could theoretically identify her. So in skipping that, everyone is stipulating to that. Do you agree with that? Do you understand what I said?
Yeah.
Do you agree?
I agree, Your Honor.
Thank you, Mr. Jonchuck. Let's bring him in, please.
Deputy Rex, we bring him on in. You can bring him in. Jury's in the jury box and is seated.
Thank you. Good morning, ladies and gentlemen. Good morning. I'm sorry you had to sit for 45 minutes. Couldn't have been avoided, but I apologize for the waste of time. I'll probably give your time. I'll be saying that a lot. Did anybody receive any information outside of court on this case? No. Okay. The next witness the state's going to call is the medical examiner. I'm going to read you a stipulation. It is an element in this murder in the first degree trial that Phoebe Jonchuck is the person who died. Both the state and the defense hereby stipulate that Phoebe Jonchuck was indeed the person who died in this case. You can rely on this stipulation as proof for this element of the first degree murder. You may call your witness.
Dr. Christopher Wilson.
And sir, if you would stand right here, opponent face this court, raise your right hand, prayer to you.
You do solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. And now, sir, if you would have a seat in the red chair. Speak in a loud and clear voice for the court. Make sure you move up close to the mic.
Good morning, Dr. Wilson.
Good morning.
Would you state your name and occupation for the record, please?
My name is Christopher Wilson. I'm an associate medical examiner for District 6.
And how long have you been a medical examiner for District 6?
16 years.
Okay. Were you an assistant medical examiner in any other place?
Yes, in Palm Beach County for 2 years.
Okay. What other education and training have you had that qualifies you to be an associate medical examiner?
Well, I'm a fully qualified physician. I completed medical school in 1994. That was followed by a 4-year residency in anatomic and clinical pathology at the Mount Sinai Medical Mount Sinai Medical Center. That was followed by a 1-year fellowship in forensic pathology at the Miami-Dade Medical Examiner's Office, and following which I worked for 2 years at the Palm Beach Medical Examiner's Office as an associate, and for the last 16 years for District 6, which is Pinellas and Pasco counties.
Do you belong to any professional affiliations or organizations?
I do.
And what are they?
The National Association of Medical Examiners, the American Association of Forensic Pathologists, and the Florida Association of Medical Examiners.
As part of your normal duties, do you perform autopsies?
I do.
What is an autopsy?
An autopsy is basically an external as well as an external examination of the body, the primary purpose of which is to determine the cause and manner of death.
And over your career, do you have an idea of how many autopsies you've performed?
Yes.
And how many would that be?
Somewhere in the vicinity of 5,500.
Okay. And have you been qualified as an expert in court as an associate medical examiner?
Yes.
Where?
In Pinellas and Pasco counties, Palm Beach County, Manatee County, and in Miami-Dade County.
And about how many times do you know?
I'd say over 100 times.
Can we approach Judge?
Sure.
On January 8th, 2015, did you perform an autopsy on a 5-year-old by the name of Phoebe Jonchuck?
I did.
Okay. Where did that autopsy was performed?
At the medical examiner's office, which is on Almaton Road.
Okay. And how do you conduct an autopsy?
Well, first I would get some basic investigation from the forensic investigator, who would be the person who first gets the information from the reporting authority. Once I get that basic information, I would proceed to the autopsy suite, do an external examination, looking for features such as the color of the eyes, color of the hair, and any external injuries. Depending on the particular case, x-rays would be done of the body. Once that's completed, I would then open up the body and perform the internal examination, which involves taking a scalpel, opening the skin, cutting the ribs, taking various body fluids for toxicology, removing the organs, weighing each organ, and examining each organ for any injuries.
In this particular case, when you conducted the external examination, were you able to determine how tall she was?
Yes. Phoebe was 47 inches in height.
Okay. And how much did she weigh?
64 pounds.
Okay. What other external observations did you obtain from your external examination?
Well, apart from features such as color of the hair and the eyes, I mean, she had medical intervention on the body, such as EKG pads, a blood pressure cuff, and she also had various injuries scattered throughout the body.
Okay. These injuries that you saw on the outside of the body, external injury, were they photographed?
Yes.
And why are they photographed?
They photographed to document the injuries in case I have to go to trial such as this.
Okay. And would those photographs be of assistance to you in showing and explaining the injuries to the jury?
Yes.
Judge, may I approach the clerk?
Sure.
Obstruction of defense counsel with Part 2 States Exhibit number 15A through Z.
You want me to approach?
Sure. have to take a recess and deal with a legal issue. I'm going to hope it would not take any longer than a half an hour. That would be 10:25. Thank you for your patience.
Hold on a second, is this something you need now? Or?
No,
All right.
something based on this.
All right.
Jury's out of the hearing, Court, Your Honor.
Okay, so whoever's faster can proffer his testimony.
I'd be happy to do it.
Huh?
May we approach just briefly before
Sure.
we do that? May I approach the witness?
You don't have to ask any of those things, just let's go.
Okay.
And identify the picture.
I am.
Judge, can I be up there since?
Sure, yeah, absolutely.
Since we're not putting them overhead.
This is photograph 15R, listen.
What was it, 15R?
Correct.
Okay.
Does this photograph show drowning?
It shows the back of the legs of the deceased.
Okay. Does that show drowning?
Not specifically, no.
Okay. Does it show where the body was found?
No.
Does it show the condition of the crime scene?
No.
Okay.
Does it show the nature and manner in which the wound was inflicted?
Yes.
Okay. And you're aware that the victim was dropped off the bridge?
Correct.
And that would be consistent with that occurring?
Possibly.
Okay. 15P, does this show the manner of death being drowning?
No.
Does it show any evidence of hypothermia?
No.
Does it show the position and location where the body was found?
No.
Does it show the condition of the crime scene?
No.
Okay.
What photograph is this?
15P.
Okay. And what is that photograph of?
This is a photograph of the back, buttocks, and the back of the legs of the deceased.
Again, that would assist you in explaining to the jury the nature and manner of the wound that was inflicted?
Yes.
15Q, Q, does this show you any evidence of drowning,
No,
hypothermia,
no,
where the body was found,
no,
the condition of the crime scene?
no.
And again, would this assist you in explaining to the jury the nature and manner of the wounds that were inflicted?
Yes.
Your Honor, I'm going to try to speed this.
Excellent.
I thought you would like that. I'm just going to page through really quick. Was the death caused by a bruise?
No,
It was caused by drowning, right?
that was the cause of death, yes.
Right, I'm handing you the rest of State's Exhibit 15. It was A through G, or excuse me, A through Z. We talked about the other three specifically. If you would page through these and then let me know when you're done. And I'm just to preview, I'm going to ask you the same questions. Do any of them show evidence of drowning, hypothermia, position and location of the body, or the condition of the crime scene? Okay, did you look through all of them?
Yes.
Okay, do any of those show drowning?
No,
Do any of them show hypothermia?
no,
Do any of them show the position and the location of where the body was found?
no,
Do any of them help explain the condition of the crime scene?
no,
Do any of the markings on the body, the bruises, or anything else really, show the cause of death?
no,
Or the contributory cause of death being hypothermia?
no.
May I have a moment, Your Honor? I don't have any further questions.
Again, this would show you and assist the jury in showing the nature and manner of the wounds inflicted?
Yes,
And part of your job is also to eliminate causes of death, correct?
correct.
So part of your evaluation, these photographs would help eliminate other causes of death, that helps you form your opinion that it was hypothermia and drowning.
Correct.
And these photos would assist the jury with that explanation.
Yes.
Okay, anything else?
Just argument, Your Honor.
Okay, do you want Dr. Wilson? I don't think he needs to be out, but if you want me to.
It's fine.
You're good to sit there if you want.
Can I take a 5-minute break to go to the bathroom?
You can, sure, go
Okay.
ahead, take as long as you want.
Okay, thank you.
You could use the bathroom back there if you want to. Up here.
There was a bathroom out
Oh, yeah.
here. Just through?
Yeah,
Okay.
definitely show you.
Thank you.
Okay, I'm listening.
Your Honor, going back, the standard for admissibility is if the photographs are relevant to prove a material fact in issue. That comes from the Florida Supreme Court in 1999, Almeida, A-L-M-E-I-D-A v. State, 748 Southern 2nd, 922. They must be relevant to a material fact in issue. As I've already cited, the Douglas case, the test for is relevancy, not necessity. And the questions I asked, do any of the photographs show the manner or contributory cause of death, that being drowning and or hypothermia. Dr. Wilson said none of those photographs show that. Number two, do the photographs show the position and location of the victim when found by police? Again, none of the photographs show that, as Dr. Wilson said, and he said, do any of them explain the condition of the crime scene? No, they do not. And he said none of those photographs show the, I just said that, the manner and cause of death. I would suggest that the state asked, do they show the nature and manner of wounds? She was not killed by a bruise. We know that she was killed due to drowning. If somebody had been hit with blunt force trauma and there was evidence of bruising that showed that, clearly that would be relevant to prove the cause or contributory cause of death. These photographs are cumulative, and of course the court always has to do the 403 analysis for any evidence that is presented, and you know, the material fact and issue here is how did she die. We have not put that in issue. We have never challenged, but that is what happened, and would certainly stipulate to anything, you know, about that. I mean, it's just not an issue. And as far as eliminating other causes of death, I'm not sure how showing a photograph of a bruise eliminates another cause of death, such that, or to the extent that it would be more probative than prejudicial. And certainly we can think of cases where that is the situation, where there are other things that have to be ruled out, but that's not the situation here. They do not do anything as to proof of a material fact and issue, and we ask that they be excluded.
Judge, I'd cite Harris versus State 843, Southern 2nd 856, a 2003 case from the Supreme Court of Florida. In that case, the court held, we have consistently held that the initial test for determining admissibility of photographs is relevant. Photographs are admissible if they assist the medical examiner in explaining to the jury the nature and manner in which the wounds were inflicted. Moreover, the photographs are admissible to show the manner of death, location of wounds, not lethal wounds, the location of wounds. If there was a stabbing in which the defendant would stab the victim 10 times, one of them only was fatal, all those other 9 cuts or stab wounds would be admissible to show the nature and location of those wounds, even though they weren't the fatal blow, so to speak, under the case law, and the identity of the victim. They said they indicated they never challenged the manner and cause of death. They ran a whole motion on hypothermia, so they have challenged that. Also, the bruising is consistent with the fall. The medical examiner said she was dropped, learned that she was dropped off the bridge from his investigator, and that's consistent with that fall, which helps confirm the manner in which the fall occurred. She was dropped from a great distance into the water, and then that led to the drowning. So it's a step-by-step process. And I think because of that step process, the fact that the location and manner of wounds are admissible, this examiner has testified his expert opinion they would assist the jury, which is required in the law, and I can give the court a copy of Harris.
Can I see it? Is it just in that folder? Can I just see it? Thank you. Do you have this?
No.
And therefore, Judge,
Do you have the sites we pulled up? Yeah.
843 Southern 2nd 856 Supreme Court. Okay, I'm gonna allow some of it in pursuant to Harris, that they definitely, my understanding from Dr. Wilson is obviously the nature and manner of death. I don't know how much hypothermia stuff we're gonna hear, but we're gonna hear drowning, and the fact that those bruises were there would be relevant to the manner in which she was placed into the water that led to her drowning, but I'm going to severely limit the quantity of those photos. And I don't,
Judge, and you have to determine what one I can use.
I know, I think you can use a few. I think you can use one photo of each wound that she would have sustained as she was being thrown in the water, whether the water hit it or the piling hit it or whatever hit her, because my understanding is there's no prior injuries to this child.
Can I approach?
Sure. And I am somewhat one face shot, and that's it. You need some time, or are we ready?
You want me to pick them out and you're gonna approve them?
Well, show them to the defense, because they know, I mean, pick one
Well,
out.
they're objecting to everything, so I don't.
Well, we're already past that. You get one picture.
First judge.
No.
Announce for the record what prints I showed them.
Well, hopefully they're going to agree, and we'll just be moving on.
Are you waiting for us or something?
Yeah, I mean, they're picking out one, they picked it out. Do you have any argument as to the one that they picked out, like you want a different one? And I'm not going to necessarily say that we're spend a lot of time on it, but.
I'll just stand by the objection to all of them.
Awesome. Okay, so those are the ones that are coming in. I don't think you need to make any kind of record, just do it. Okay, let's bring the jury in, please.
Liberty Rice, line them up, bring them in.
I got Mr. Dillinger's first name
Hmm?
on the stipulation. John.
Oh, sorry.
You want a cough drop?
That might help, thank you.
You can take more than one.
Sure, thank you.
Oh, thank you. Can you hold just a second?
Deputy Rice, hold
Let's
on.
come up with a question. Deputy Johnson, remind me of that.
Yes, please.
All right, Deputy Royce, bring him in.
Thank you for reminding me.
Switch from water to coffee to water now. Jury's in the jury box and seated, Your Honor.
Okay, ladies and gentlemen, I have one question, so I have to read it to you all and figure out who wrote the question. When in custody in Manatee County, Mr. Jonchuck went to the restroom. Is it general practice to observe the defendant, or was he allowed to use the restroom in private? If I could ask who wrote the question.
I did not.
Okay, thank you. I have to note that. And your name is?
Myra, it was on.
Thank you. And did you write that this morning or yesterday?
Yes, ma'am.
Okay. The witness who could have testified about that is been excused, is that correct? I think so.
Yes, sir.
Okay. We are going to try to get the answer through another witness who has yet to testify.
Thank you.
You're welcome. You may proceed.
Judge, at this time I introduce this exhibit number 15, IOZQRWP into evidence and published. May I publish them to the jury?
Yes, received over defense objection.
Sure, what's been marked as exhibit number 15P. What is that a picture of, Doctor?
It's a picture of the back, the buttocks, and the back of the legs of the deceased.
Okay. And what is that number in the picture?
That's a specific number that we give to each case. In this particular case, the number was 5150043.
So that was tied to Phoebe Jonchuck.
Correct. It's a unique identification number.
Okay. And would you? What is this area? What are the injuries here that you're seeing?
That's the back of the left thigh, and you can see this on the upper aspect near to the buttocks is very clear, sharp line of demarcation between the upper and the lower aspect, and you see that.
Would you stand up and show us with your pointer, please?
Sure.
That is all right, Judge?
Yeah, that's fine.
I'm referring to this area here, which, as you can see, has a purplish reddish discoloration. That's a contusion or a bruise. And the significant thing to this injury is how very sharp this line is here, as well as the circular areas of paleness here, indicating to me that this is a patterned abrasion. You don't get this from, some irregular object hitting the skin. This is clearly a pattern of something with a sharp line here and 2 holes here hitting the skin.
Would be consistent with someone being thrown off a bridge and perhaps
again,
hitting a pylon or something?
Yeah, it depends. I mean, when I looked at this particular injury at autopsy, I specifically asked if there was anything on the bridge, or maybe some rivets on the side of the bridge that she might have impacted. As far as I could determine, that was not the case, but it had to be some specific object that she hit.
And stand, this is 15W. What is that a picture of?
Again, that's a close-up of that previous injury. Again, note the paleness here and the very sharp line of demarcation of the bruise here, as well as these patterned circular areas of pallor within the actual bruise, indicating that this is a patterned contusion, patterned bruise from some object of that shape impacting the back of the left thigh.
And what is that a picture of? This is 15R.
This would be a picture of the back of the thighs going down into the lower legs and the feet. Again, on the upper aspect, you see that pattern abrasion. And as you come along here, you can see some also some areas of contusions on the back of the left thigh and the maybe an abrasion on the left ankle here.
And this is 15Q.
This would be the back of the head, the neck, and the upper back of the deceased. Of significance would be this area on the left back, where you can see these purple areas of discoloration, which again are contusions or bruises as some blunt object or objects hit the back of the deceased.
This is 15Z.
Again, this would be the back of the head going into the neck here. A closer up picture of the back of the left shoulder going into the left upper back. And this is a close-up of one of those contusions or bruises on the left upper back.
15O.
This would be a photograph of the lips of the deceased, upper lip, lower lip, the teeth, and specific reference from the ruler, right above the ruler, is this area of abrasions, possibly a laceration on the lower lip of the deceased.
The color of the lips.
The lips look, well, the lips look kind of cyanotic or blue in appearance, probably because of the low temperature of the deceased.
And 15I.
Photograph of the front of the legs of the deceased. This aspect here would be the thighs, going into the knees, going into the lower legs. You can see evidence of medical intervention in these intraosseous catheters, and you can see various areas of purple discoloration on the left knee. Again, these are contusions from blunt objects hitting the deceased.
That's all the picture photograph. After you conducted your external examination, did you conduct an internal examination?
I did.
And what did that reveal to you?
Basically, there was the lungs had what are called petechiae on the external surfaces or the pleural aspects.
What does that mean, petechiae?
Petechiae are like pinpoint hemorrhages on the surface of any body tissue. In this particular case, the lungs. Usually occurs when very small blood vessels rupture and can be found in cases of asphyxiation.
Asphyxiation is unable to breathe?
Basically, it really refers to the lack of oxygen. Could be caused by any number of things. The most common being somebody choking, somebody asphyxiating, like say on a steak if they happen to swallow the steak and it sticks in the throat, or in drowning.
Okay. What else did you discover during your internal examination?
Within the lungs, within the bronchi, which are the tubes that go into the lungs and go through the lung architecture, was copious frothy fluid. Again, that's seen in cases of drowning.
Okay. What history did you have from your investigator regarding the death of Phoebe Jonchuck?
So the basic information was that...
Hearsay?
Go ahead.
Basic information was that the girl was thrown over the Dick Misener Bridge by the father. The body was recovered about 90 minutes after that event occurred, taken to the hospital where they attempted resuscitative efforts, and after 30 minutes she was pronounced deceased.
What was the height of the fall?
Approximately 60 feet.
And what was the air temperature?
I don't know what the air temperature was, but according to my investigator from Bay News 9, the water temperature was 67 degrees in January of 2015.
Do you know how long she was in the water?
Approximately 90 minutes.
Okay. And why is it important to know that surrounding history when doing your examination?
Well, this is the Tampa Bay area. In cases of drowning, I mean, there's no really specific set of findings that would definitely, indicate that somebody drowns. I mean, it's basically on the circumstances such as whether the person can swim, how well they can swim, currents in the area, that type of stuff. Also, with respect to contributory condition of hypothermia, you need to know what the temperature of the water is, how long they're in the water, things like the core temperature when they came out, how long
What was the core temperature of Phoebe Jonchuck when she came out?
In the ER, the core temperature was recorded as 7 degrees Celsius, which is 44.6 degrees Fahrenheit.
And what's the normal temperature?
Normal temperature would be 98.6 degrees Fahrenheit.
So this is about half or so of the normal temperature, even less than half.
It's very cold, yes.
Were they able to raise her temperature in their life-saving efforts?
They did. They surrounded her by warm blankets and infused warm IV fluids and got her temperature up to 24 degrees Celsius, which is 75.2 degrees Fahrenheit.
Were you able to determine within a reasonable degree of medical certainty the cause and manner of death?
Yes.
And were you able to, within a reasonable degree of medical certainty, determine any contributory conditions?
Yes.
All right. What was the cause of death?
Cause of death was drowning.
What was the manner of death?
Homicide.
And what was the contributory condition?
Hypothermia.
The bruising that we saw, does that have to occur while you're alive?
Absolutely. In order for a bruise to have that purplish appearance, it means that the blood vessels under the skin have ruptured and blood is actually flowing into the injured area. So for blood to flow, the heart has to be pumping, so the person is technically alive.
Yes. The frothy fluid in the lungs that you described?
Yes.
That is evidence of drowning?
It's a finding. It is not necessarily pathognomonic of drowning, but it is found in many cases.
And the petechiae in the lungs, similar?
Yes, again, found in cases of asphyxiation, of which drowning is a reason to asphyxiate.
The photographs that the state judge just presented to you, none of those photographs proved drowning, correct?
Not in it and of themselves, no.
Okay. Or showed any external evidence of that?
Of drowning specifically?
Correct.
No.
And same with hypothermia. None of those photographs showed direct evidence of hypothermia, correct?
Correct.
Okay. Nothing further.
Anything further?
Part of your job is to rule out other things that could have happened?
Yes.
And so you, in your examination, you ruled out other possible causes of death?
Yes.
Okay. And you determined that it was drowning with a contributory factor or contributory condition of hypothermia?
Correct.
And those photographs are consistent with someone being dropped off the bridge and the impact and impacting. Those photographs are consistent with being someone being thrown off the bridge and impacting the water and impacting things in the water, consistent with the story you gave, which would be consistent with the drowning.
Correct.
Nothing further, Judge.
Anything further? Okay. Can Dr. Wilson be excused?
Yes, Judge.
Defense, would you want him on standby?
No, you're
okay. Thank you for your testimony, Dr. Wilson.
Thank you.
Anybody have a question for Dr. Wilson? Raise your hand if you think you do. Okay. Thank you, Dr. Wilson.
Thank you.
May I call your next witness?
State calls Detective Thad Coffin.
right here, please, clerk, raise your right hand, correct, take you.
Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. And now, sir, if you would have a seat in the red chair. Speak in a loud and clear voice for the court, make sure you move up close to that mic.
Okay, thank you. Good morning. Would you please state your name for the record?
Thaddeus Coffin,
And how do you spell your first and last name?
Thaddius, and last name Coffin.
And how are you employed?
I'm a detective with St. Petersburg Police Department.
How long have you been with the St. Petersburg Police Department as a police officer?
About 14 years.
Okay. And can you briefly describe your training experience leading up to your current assignment?
My current assignment right now is digital forensics and computer crimes. Throughout my time at the police department, I was a police officer and then became a detective to my current assignment. In order to do the things that I do, I've had a lot of training in reference to digital forensics and computer investigations. Some of that training includes training on how to dump information from cell phones and how to conduct computer crimes investigations. Specifically, taken classes from XRY, which is a vendor that dumps information from cell phones. Taken classes from Teal Tech, which are much more technical in that they require you to kind of get down and dirty with the cell phone. So the specific classes I've taken with Teal Tech are bootloader and flasher box, ISP, which is in-service programming, chip-off forensics, which involves removing a chip from a cell phone. I've also taken several classes and trainings for examining computers. A lot of those are sponsored by the federal government and other folks. So I've taken SCURS, which is sponsored by Department of Homeland Security, and I've taken Axiom programming class. I'm sorry, an Axiom computer review class, which includes parsing through data from a computer.
I'm sorry, can you repeat what you did for the last part?
Yeah, taking an Axiom, AXIOM, kind of computer review class, which entails parsing through data from computers.
Okay. So you told us about your experience and some of your training. What are your day in and day out duties as the computer forensic detective for the St. Petersburg Police Department?
Day in and day out duties focusing on digital forensics includes people, other detectives mainly bringing me electronic devices to try and get information from. So depending on the case, it can be more intensive.
Are you the primary computer forensic detective for the entire St. Petersburg Police Department?
I am the main one, yes.
In this case, did you have an occasion to examine a cell phone, a smartphone?
I did.
Was that the smartphone belonging to the defendant, John Jonchuck Jr.?
It was, yes.
Okay. So can you tell me what you were tasked with doing with this phone?
This phone had been recovered from the scene and was not able to turn on. So my task was to get the data from the phone.
Now, when you received the phone, can you describe the condition of the phone when you received it?
Yeah, it was a whole cell phone, except the screen was damaged, severely cracked. And again, when I tried to turn it on, it would not turn on.
So what did you do from that point?
From that point, you have to try and get power to the device. In this particular case, batteries often fail, so I took out the battery and used what we call banana clips. Banana clips are basically hardwired power source to a phone, so you don't have to charge it or anything like that. It plugs in to a USB device and then powers the phone directly. That did not work either. After that, because there's no power to the phone, we had to move on to more extreme methods to try to get the data from the phone.
And what were those methods that you used?
The chip-off process.
Okay, can you describe the chip-off process to the jury?
Yes. So the chip-off process, you have your cell phone, and inside the cell phone there's a motherboard. On the motherboard there's all kinds of chips and transistors and capacitors and whatnot. The data that rests on a cell phone is on one chip, one microchip. So your goal on a chip off is to remove that chip and dump the data from that chip directly. Typically don't like to do this because it is destructive to the phone. This is the last resort to try and get information from a phone. So in this case, that's what I had to do. Utilized the methods that we have, pulled the chip off, and I was not able to get a dump from the chip.
You were not able to get what from the chip?
Information dump.
And that's a common term that's used by forensic experts, correct?
That's correct, yeah.
All right. And are you referring to data?
Yes. Data.
So by taking the chip out, you said that there was damage to the actual plastic components of the phone, correct?
Yes.
Does that in any way impair the data that's on the chip?
No, definitely not.
Okay. So would the data still be on that chip even though the phone was dismantled to get to the chip?
Yes, and that's the purpose of the chip-off process.
Can you tell them in detail what you did with the chip, starting with how you removed it from the phone and how you attempted to extract data from it?
Certainly. So this particular phone, the method that we have here locally is to use heat to melt a chip off of a motherboard. And essentially the chip is attached by solder and by epoxy. So you have to heat that up in order for the solder and epoxy to melt. That way you can lift the chip off. This particular phone had a chip on the bottom side, the processor on the bottom side. So the method that we prefer to use is bottom heat, what we call bottom heat. So we put the motherboard on a heating plate so heat comes up from the bottom and heats up the motherboard slowly because we don't really care about the motherboard. Our goal is to get the information off of the chip. So slowly start heating that up, but because of the chip on the bottom, it was absorbing a lot of the heat from our target chip, the memory chip. So I had to use top heat to blow heat down onto the memory chip to melt that solder and that epoxy. Eventually, the chip came off, and after that, I have to clean it up and attach it to, I have to clean it up and then what we call reballing. So on the bottom of microchip, there are all kinds of very tiny, tiny little pads, probably 100 or so on a small little microchip this big. So you have to reball those little pads so that with solder so that you can attach wires to them and pull out the data. In this case, I got the chip reballed, put it in our chip reading adapter, and attached it to the computer.
Can you explain the reballing process?
Certainly.
What do you do to reball it?
So in order to reball a chip, you pull it off the motherboard. It's dirty, it's grimy underneath, it's got epoxy, it's got solder all over the place. It's just a nasty mess. You have to clean it up with a soldering iron. You have to clean all that off using a microscope or some sort of magnifying device. Clean it all off, make it nice and pretty, and then you apply soldering paste, which is almost like applying butter to a piece of toast. You just slap it on, and then you apply some heat, and just like butter, it melts. Except within that soldering paste, there's solder, and that attaches itself, self-attaches to the pads on the microchip. That creates kind of the soldering beds that we want to implant the wires or attachments to. That way we can read the information off of the chip.
And did you do that in this case?
I did, yes.
And what happened?
Nothing. I could not get a good read.
Okay. And how many times did you attempt to get a good read off that chip?
Approximately 8 to 10 times. I tried several times.
And each time, your 8 to 10 times, you were unsuccessful?
That's correct, yes.
And in that process, was the chip damaged at all?
No, no. It looked to be fully functioning, clean. The pads look good.
Is the chip still in good shape?
It is still in good shape.
Was the chip and the other components of the phone provided to the defense in this case for John Jonchuck Jr.?
It was, yes.
Okay. And what we on? to your knowledge, has that chip and the components with the chip been returned to the St. Petersburg Police Department?
I don't know that it has.
That's all I have.
Ross?
Good afternoon, or morning still. Good morning, Detective Coffin.
Good morning.
All right. Now, may I approach the witness? I'm approaching, I'm showing you what's been pre-marked as defense 4A through 4D, marked up for identification. Can you take a look at those? Let me know if you recognize.
I do recognize them, yes.
All right. And what do these photos depict?
They're pictures of the result of the phone after the chip-off process.
Okay. And do they fairly and accurately depict the phone as you left it?
Yes.
Okay. At this time, Judge, I'd ask to introduce to evidence 4A, defense 4A through 4D.
No objection.
No objection.
Proceed.
So, fair to say you indicated that the phone was turned over to the defense in this case, right?
Yes.
And this is the condition of the phone when it is turned over to the defense, correct?
That's correct, yes.
Permission to publish? Yes. Now, when the phone was provided to us, you were not even listed as a witness, correct?
I assume. Probably correct, yeah.
And you did not write a report in this case, correct?
That's right.
So, and do you know what date you were listed as a witness?
No.
Objection, Your Honor. That's completely irrelevant.
There was some insinuation that the defense...
Come on up. Come on up.
prior to you obtaining the phone, Lisa Vanderbilt had the phone, correct?
That's correct.
She's
yes.
a detective with St. Pete, correct?
She is, yes.
And she wrote a report basically just indicating she couldn't get anything off the phone, right?
Objection to hearsay.
What's his name? I'm gonna overrule that. Go ahead.
She wrote a report indicating just basically the bare minimum, I couldn't get anything off the phone initially, right?
That's correct, yes.
And after her deposition, you were contacted by the state about coming in to explain further, correct?
Objection again to hearsay and irrelevant.
Overruled.
Yes.
Okay. So up to that point, nobody had asked you to provide any report detailing this chip-off procedure, right?
Not to my recollection.
Okay. And so when the defense took possession of the phone, it's in a bag with all these pieces and there's no report explaining why, correct?
Right.
Okay. Now, you received the phone on November 20th of 2017, right?
That's correct, yes.
And your, with the time you received it, the phone was not operable, right?
That's correct, yes.
But you believed it was a good candidate for the chip-off process, correct?
I did.
And part of that reason you believed it was a good candidate for the chip-off process is because the phone was operable at the time it was collected, correct?
Yes.
Now, you were trained in this chip-off procedure yourself in October 2017, correct?
Correct.
And this case you handled in November 2017, right? November 27th, I believe?
Yes, ma'am.
Is that right? Okay. Fair to say you're the only St. Pete detective or officer that is trained in the chip-off technology, correct?
Yes.
And so when you did this, you went down to PCSO to kind of have, they have the technology and to also kind of assist, right?
Yes.
So there's somebody in law enforcement locally that, other than you, that knows how to do this chip-off procedure, right?
Yes.
Okay. Fair to say you are not aware of any experts who do this procedure for defense attorneys?
That's correct.
You tried a number of times to build up the chip and be able to get some information from it, right?
Yes, ma'am.
Unfortunately, you weren't able to, right?
That's correct.
But you're not willing to give it another try either, right?
No, I mean, once you get to about 10 tries, more is kind of irrelevant.
Okay. And as far as why you're unable to get any information from the phone, you can't really say if it was a problem in perhaps building up the nodules you were talking about, or if there was some prior damage to the chip, correct?
That's right, I cannot say.
Okay. And some things that could damage the chip could be water damage or heat, those kinds of things, right?
Yes, ma'am.
Dropping the phone.
Yes, ma'am.
And absent there still being water sitting in the phone, you wouldn't know if any of those things happened, right?
That's correct.
So the phone could have been damaged during the course of storage or something, correct?
Yes, ma'am.
I don't have anything further.
Anything further from the state?
Just briefly, Your Honor. Detective, who asked you to do this chip-off procedure?
Detective Vanderbilt said that she couldn't couldn't succeed with getting a data dump or get the data from the phone through our normal processes. So she suggested it was confirmed with Detective Miller that it was authorized, and then I went forward with it.
Okay. And so were you getting your instructions to do the chip-off procedure from Detective Miller?
Yes.
Is he the case agent in this
He
case?
is, yes.
And Detective Vanderbilt is also a detective who does forensic work?
Yes, she does. Yes.
Who is more specialized, Detective Vanderbilt or yourself?
I am.
And the photographs that were just shown to the jury of the phone, who took those photographs?
I believe the defense did.
Okay. And did you also document the phone as well in photographs?
I did, yes.
Okay. Did you document the different stages of your procedure as you did the chip-off through photographs?
Yes, I did.
Okay, and were those provided and made available?
Yes, they were.
All right. And you said you did not write a police report. Do you always write a police report every time you do a chip-off?
I certainly try, but we get extremely busy, so not every time, no.
All right. But did the photographs fairly and accurately document what you did in this case?
They did.
Okay. Have more, Your Honor?
Sure.
Go ahead.
Anything further?
No, Judge.
Okay, can Detective Coffin be excused or stand by?
Stand by, Your Honor.
All right, you're on stand. Oops, any questions of Detective Coffin? No. All right, you're on standby. Thank you for your testimony.
Thank you, ma'am.
You may call your next witness.
State Police Officer Michael Carter.
And sir, if you would stand right here for me, please. Face this court. Raise your right hand and start to take the oath.
You do solemnly swear to affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
And now, sir, if you would have a seat in the red chair. Speaking a loud and clear voice for the court, and if you will close to the mic.
Good morning, officer.
Good morning.
Morning.
Good morning.
Would you please state your name for the record?
Michael W. Carter.
What is your occupation?
I am a police officer of the city of St. Petersburg, Florida.
And how long have you been a police officer?
Approximately 16 years.
What's your current assignment?
I am working in our downtown deployment unit.
Okay. And what are your duties there?
I work with the bars in the downtown area.
Okay. And do you sometimes work with Officer Julie Bryan, who works there as well?
Yes, I do.
And what was your assignment on the evening of January 7th, 2015?
On this night, I was working the bars downtown. I was in the area of the 100 block of First Avenue North.
So I want to draw your attention to just after midnight, which would be the first few minutes of Thursday, January 8th, 2015. Did you receive a radio traffic that something had happened?
Yes, there was a radio transmission of a officer who was behind a vehicle that was stopped on the Dick Misener Bridge, and the subject got out of the car, removed a child from the car, and dropped him off the bridge.
What did you do when you heard that?
At that point, I got in my vehicle and I responded to the area.
Okay. And where'd you go specifically?
I went first to the north fishing pier and circulated the area, trying to locate the vehicle at that point.
Okay. And were you in a marked police cruiser?
Yes, I was in a marked police cruiser at the time.
Full uniform?
Full uniform.
Just like what you're wearing today?
Yes.
Okay. And so, where's the north pier in relation to the Dick Misener Bridge?
It's in between the Dick Misener Bridge and the Skyway itself, Skyway Bridge itself.
And did you have any car cameras or body cameras at that time?
No, I did not.
Okay. So, did you see anything related to this case when you were at the North Pier?
When I went by the Dick Misener Bridge, the officers were still on scene trying to locate the female at that time.
Okay, but you kept going and went to the
yes,
pier?
I continued going, trying to locate the vehicle.
Okay. Which vehicle were you looking for?
The white PT Cruiser.
Okay. And did you see the white PT Cruiser anywhere north of the Skyway?
No, I did not.
What happened next?
While I was in that area, it was called out that that the vehicle was located and was going northbound. It had went northbound from I-275 on to 75, and a officer was behind it. Officer Gillis had gotten behind the car and was trying to pursue the car at the time.
Okay. What happened next?
At that point, Officer Gillis called out that the car was doing a U-turn, was coming back at her, and then started going southbound in the northbound lanes of I-75.
What did you do?
At that point, I continued southbound on I-275, on to 75, continued southbound until I was able to catch up with the pursuit, which was just north of exit 213 on 75.
Do you remember how fast you were going to get there?
At one point, approximately, I was doing about 137 miles an hour southbound on I-275.
Were lights and sirens activated?
Yes, sir. Lights and sirens activated, and everything going.
What did you see when you arrived at exit 213 on Interstate 75?
At exit 213, that's just north of there, I was observed the Highway Patrol and Sheriff's Departments from other agencies. I had the road blocked for the northbound lane to keep from the traffic from flowing. I saw other vehicles behind the vehicle in pursuit, and at that point, observed the car coming to a stop.
What happened next?
At that point, I pulled into the median, exited my vehicle, approached the vehicle that had stopped in the northbound lanes. I observed a deputy having the driver at gunpoint, and I approached, along with 3 other officers, the driver's door of the vehicle.
And what was the make and model of this vehicle?
It was a white PT Cruiser.
What was the tag for the vehicle?
It was Delta Echo Romeo Papa 27.
Okay. What happened?
At this point, the gentleman that was in the vehicle was hands on the steering wheel, looking straight ahead, not responding to any commands that the officers were giving him at the time. He refused to unlock the door. He refused to exit the vehicle. At this time, an officer, Souza, made a decision to smash out the glass to try to remove the subject from the vehicle.
Which St. Petersburg officers were there with you?
The officers from St. Pete were Officer Gillis and Officer Laberte and Officer Souza.
Okay. And
along
where,
with myself.
And where were you in relationship to the defendant who was sitting in the vehicle?
I was at the driver's side mirror by the front fender at that point, and the other officers were in between me and the rear of the car.
Okay. So what happened after Officer Sousa broke the window?
After the window was broke, the defendant still did not respond to commands. We tried to extract him from the car at that point. His seatbelt was still attached, and we could not extract him from the car.
Okay. Was this a tense situation?
Yes, very intense. People were still yelling commands at him at the whole time. He was still holding on the steering wheel and was refusing to let go.
What happened?
At this point, we realized that the seatbelt was still buckled on, and we had to have somebody come in from the passenger side to unbuckle the seatbelt because none of us could reach it from the driver's side.
And what happened after the seatbelt was unbuckled?
Once the seatbelt was released, we were able to extract the subject through the window of the car, put him on the ground, and get him in handcuffs.
And what was the reason they just didn't open the door from the exterior of the vehicle? Was the vehicle locked?
The vehicle was locked, but at that point, with the situation being intense, and with him still holding on to the steering wheel, he was pulled through the window of the car with it being smashed out.
And what happened after he was pulled out?
He was pulled out, he was placed on the ground, he was handcuffed. At that point, he was escorted back to his feet, and he was escorted to my cruiser, which was parked in the median, which was the closest cruiser at the time.
Okay. Approach the witness. Officer, I'm showing you some photographs. These are states 13A through 13P. Would you take a look at those without showing those to the jury? These photographs fairly inaccurately depict the defendant and also the white PT Cruiser that you just testified to.
Correct, they do.
Your Honor, at this time, the state is asking to admit into evidence what is pre-marked as states 13A through P as 13A through P.
No objection.
Received.
Permission to publish?
Yes.
Officer Carter, if you'll just turn your attention to that monitor for your shoulder. this the white PT Cruiser that you were just testifying about?
Yes, it is.
Was this photograph taken when the vehicle came to a stop at the roadblock in Manatee County
Yes.
at exit 213? And that was 13A. It's 13B. Is that the interior of the vehicle?
Yes, it is.
That shows some of the glass from the window being broken.
Right, from the glass being smashed out towards the inside of the vehicle.
It's 13C. Similar view of the interior of the vehicle.
Correct.
It's 13D from the other angle, correct?
Yes, it is.
It's 13E. Is this the backseat area of the vehicle?
Yes, it is.
This is 13F. What is this?
That is a child's booster seat.
It's 13H.
That's from the passenger side door.
This is 13I. Where's this?
That's the rear trunk of the car.
It's 13L.
Same picture as before, just a further view out with the license plate in the picture too.
What is the license plate in this photograph?
DERP27.
Is that the same tag called out by Officer Vickers?
Yes, it is.
This is 13J. Where's this?
It's the rear trunk of the car.
And what are these items?
It looks like child's toys.
N.
That would be the driver's side of the vehicle.
13O.
That's from the front passenger side.
Is this a police cruiser here?
Correct.
Part of the roadblock?
Yes.
We have 13K, again.
That's a picture of the license plate, as we stated from earlier.
13P. Who's that?
That is Mr. Jonchuck, as he was taken from the vehicle and transported to St. Pete's station.
Was that photograph taken at the St. Pete station?
Yes, it was.
January 8th, 2015?
Correct.
That's what he was wearing when he was extracted from the vehicle?
Yes, it was.
Did the defendant make any spontaneous statements to you when you transported him from the Manatee County roadblock where he was arrested to the Manatee County Sheriff's Office?
Yeah, he made two spontaneous statements. One was, the first one is she will only live with him, and that he asked for me to take him to the Tampa airport.
Okay. And did you ask him any questions to elicit those statements?
No, I did not.
Okay. Was it your job to ask questions while you transported him?
No, it was not. My only job was to transport him from the scene to the Manatee Sheriff's Office.
Okay. And did you also transport him from the Manatee County Sheriff's Office to St. Pete Police Department?
Yes, I did.
Okay. And from there,
To where?
To the Pinellas County Jail.
Okay. Now, when you were at the Manatee County Sheriff's Office, did you stand by with him?
Yes, I stood by outside the interview room for the entire time that we were there.
All right. At some point, did he go to the bathroom?
Yes, at one point, myself and a Manatee County deputy escorted him to the restroom.
Okay. And was he allowed to go into the restroom by himself?
No. Anytime anybody's in custody, they have to be monitored the whole time. We actually stepped inside the restroom while he was there.
All right. What was his demeanor like when you were seeing him at the Manatee County Sheriff's Office and transporting him?
He was very quiet, non-emotional, except for a couple of times he would almost appear to be trying to make himself to forcefully cry. And then that time would only last.
You can answer.
Would only last for like a couple of seconds, and it would just go back to like a blank look.
It didn't appear to be genuine crying to you?
No, it was not. It was like he was forcing himself to create tears.
How many times did that happen?
A couple of times.
When you were transporting him from the St. Petersburg Police Department after the photographs were taken and clothing was collected to the Pinellas County Jail, did he make any spontaneous statements on the way to the jail from St. Petersburg Police Department?
Yes, he made 3 spontaneous statements at that point. He said at one point he did not throw her off the bridge, that he dropped her into the water. He stated that you don't know what I've been going through, and he also made a statement as he did not know what he did wrong.
Okay. Was he booked into the jail?
Yes, I stood by until he was booked in the Pinellas County Jail.
Do you see him in the courtroom today, the defendant that was extracted from this white PT Cruiser that you helped extract from the PT Cruiser and that you transported that night?
Yes, he's sitting in the over here to the left in a white button-up shirt with a tie on, tan pants.
Yeah, would the record reflect that the witnesses identified the defendant?
Yes.
Have a moment, Your Honor.
That's all I have.
Cross.
One moment, Judge.
Mr. Rosari, did that answer your question?
Yes, ma'am.
Okay. And in the future, if anybody has a question, that's the way to do it. Write it on a piece of paper, hopefully before the witness is gone and available for that. Thank you.
Morning, Officer Carter.
Good morning.
You mentioned when you were heading out to the scene of the traffic stop, or where Mr. Jonchuck actually came to a stop, you're driving about 137 miles per hour at some point, right?
Yes, I was.
fair to say that's you playing catch up, right?
Yes.
There was no indication that Mr. Jonchuck, after leaving the Dick Misener Bridge, was ever going over 70 miles per hour, correct?
I have no call. I can't say that.
Would it refresh your recollection to review the dispatch notes you referred to a number of times?
Yeah.
May I approach the witness, Judge?
Sure.
Can I see that?
What is this? The dispatcher notes?
The dispatch notes, yeah. Refreshes your recollection on whether anybody ever indicated he was going faster than 70.
That would be the officer calling that out that was behind him.
So that'd be up to Sousa's account then, right?
Yes. No.
So you don't have any information he was going anything over than 70 then, right? Is there anything in there that suggests that?
No. Not from what I'm seeing here.
Your Honor, I'm going to object. She was refreshing his recollection, and now she's questioning about the document.
Sustained.
So the first time you have eyes on the car's already come to a stop, right?
Yes, it was coming to a stop. It wasn't at a complete stop yet, but it was coming to a stop.
All right. And the officers all start surrounding the vehicle, correct?
Correct.
Number of officers, right?
Yes, like I stated earlier, there was a Manatee deputy already had him at gunpoint.
Right. And shouting commands, right, at him?
Yes.
And multiple officers had their guns drawn, right?
He's the only one I saw, but yes, probably, I'm guessing yes, so.
You were most focused on Mr. Jonchuck, right?
Yes.
And at no time did you see him do anything other than continue to grip the steering wheel as he drove up, right?
Correct, at that point, yes.
So he drove up gripping the steering wheel and he stayed gripping the steering wheel, right?
Yes, until we pulled him out of the car, yes.
And stared straight ahead, right?
Yes.
Not responding to any commands that anybody's yelling at him?
Correct.
You guys start breaking out the windows, doesn't respond to that, correct?
Correct.
He doesn't ever turn his gaze from straight ahead, correct?
No, he did not.
And to be clear, you guys had to break out multiple, or you did break out multiple windows, right?
Yes.
Okay. And when you got the window broken out, you couldn't get him out because the seatbelt was fastened, right?
Correct.
There was a child car seat in the back seat, right?
The booster seat, yes.
Booster seat behind the passenger side?
Yes.
Once you were able to, or you all were able to undo the seatbelt, he didn't struggle with y'all as you were trying to pull him out of the car, right?
No.
Just basically dead weight, right?
Dead weight, and he still had a hold of the steering wheel.
Okay. And he never pulled himself away or anything from y'all, right?
No.
Okay. No indication that Mr. Jonchuck was under the influence of alcohol or drugs, correct?
Not that I could tell at the time.
And you had eyes on him. You drove him to Manatee, right?
Correct.
And you had eyes on him at Manatee, correct?
Correct.
Now, St. Pete Police Department doesn't wear body cams, right?
No, we do not.
And hardly have any cruisers with cameras in it also, right?
I do not have one in mind.
The cruiser that Mr. Jonchuck was placed into doesn't have video recording, right?
As I said earlier, I do not have a camera in my car.
It's a fully marked police cruiser that you were in though, correct?
Correct.
You got a light bar on top, right?
Yes.
You have the insignia on the side?
Yes, I do.
You got the cage in the back?
Yes, I do.
Okay. While John's sitting in the back of that car, he starts asking for his Bible, right?
He didn't ask me for it, but there was a sergeant at the time that was talking to him, yes, and I was asking for a Bible.
And you transported that giant Bible to Manatee County Sheriff's Office, correct?
Correct.
So somebody retrieved it from Mr. Jonchuck's car, and you took it with yourself and Mr. Jonchuck to Manatee, right?
Yes.
It wasn't knocking, was it?
No.
No? When Hubble is speaking to him in the back of the car, you can't hear, or you're not privy to the entire conversation, right?
No, I could not hear. There was cars going, sirens going. I couldn't hear the conversation in between Sergeant Hubble and Mr. Jonchuck.
But you do hear John say something about Michael, right?
I don't know if I heard it from him or if I heard it from somebody else making a statement.
So either he or somebody else said something about Michael to him?
Not that I recall, but something was said about it.
You don't remember what was said?
No.
You told John that you heard him saying something about, you heard John talking about Michael when he was in the back of your car, right?
Not that I recall.
Would it refresh your recollection to review the transcript from Manatee?
From Manatee?
Mm-hmm.
Yeah.
You were there, right?
In Manatee County, yes.
May I approach the witness, Judge?
And this is the transcript from, you're saying from Manatee, what of from Manatee?
The interrogation room.
Okay.
Does that refresh your recollection about what you said to John?
Yes.
And you agree that you told John that the first thing he was saying at first was something about, what he was saying at first was something about Michael out there at the scene, right?
Yes.
You would agree you didn't include that anywhere in your police report, correct?
No, I did not.
I'm guessing you don't have any additional details about what he said about Michael for us today, do you?
No, I do not.
Objection, that's argumentative.
Do you have any additional details about what he said about Michael?
No, I do not.
Do you hear Hubble when she's asking John about who he dropped in the water?
Objection, that's hearsay, Your Honor.
No.
So prior to you transporting him, while he's sitting in the back of the cop car, he demands or requests you guys to get his Bible from the car, right?
So I'm guessing I was told the Bible was removed from the car.
And he's saying something about Michael back there, right?
Yes.
And then you transport him, right?
Correct.
And while you're transporting him in the back of the police car, he's in handcuffs still, right?
Yes.
He's got that cage in front of him, right?
Yes.
And he asked you if you'll just take him to the airport, right?
Yes, he did.
He also asked you to take him to Babylon, correct?
Yes, he did mention something about that, yes.
You didn't put that in your report either, did you?
No, I did not.
And you testified on direct that he said the only way she will live is with him. What he actually said to you in that car was the only way he will live is with him, correct?
Yes, I probably read the wrong statement from the depot, yes.
And so John doesn't use the words I or me or her at all, right?
No.
He says the only way he will live is with him, correct?
Correct.
You didn't include that in your report either.
No, and in my depot it even stated that I was supposed to do a follow-up, and I forgot to do the follow-up with that, yes.
You agree that during the entire time you were with John, he was emotionless?
Except for the couple of times that he was fake crying, yes.
Okay. And the fake crying you also didn't put in your report, right?
No.
You thought that his demeanor was off for somebody who had just lost a child, right?
Objection is to his opinion, Your Honor.
Right?
Yes.
He was just too calm, correct?
I felt so, yes.
When you have him down at Manatee, at some point you're asked to help take John to the restroom, right?
Yes, I did.
How far is the restroom from the interrogation room?
A couple rooms away. I have no idea.
Okay.
I don't recall that. I don't recall that building. I just know we went through a couple doors and then to the restroom.
Okay. Fair to say, though, on the video from at no point was the video stopped, the recording didn't stop with the video, right?
I have no idea. I don't know how their establishment works. I'm saying probably not.
So you would be comfortable in us judging the time he was gone from when he exited the room to when you guys walked back in the room?
Yes.
Okay. And when you guys got to the bathroom, John indicated he couldn't pee, right?
I don't recall. Honestly, I don't know if he actually urinated or not.
Okay.
From my understanding, I thought he did, but he may not have been able to.
May I have one moment, Judge? Mm-hmm. All right, officer. So after John is taken from the interrogation room, you then transport him back to St. Pete, right?
Yes, I did.
And at that time, he says to you that you don't know what I've been going through, correct?
No.
He didn't say that to you?
No, not then.
When?
He said it from when I was transporting him from St. Pete to the Pinellas County Jail. As I testified earlier, I stated that he made those 3 statements.
I'm sorry,
on the
so
way.
you're in Pinellas County, though. I'm sorry, from the St. Pete jail, not Manatee, from St. Pete jail to, or from St. Pete Police Department to Pinellas County Jail.
Correct.
He tells you, you just don't know what I've been going through, right?
Yes.
And he also asks you what he did wrong, correct?
If I refer to my report, I'll tell you exactly what he stated.
Sure. The suspect wanted to know what he did wrong?
Yes.
Nothing further.
Can you read the record?
Briefly, Your Honor, yes. So I want to go back to those statements. He didn't just say that he didn't know what he did wrong by itself. He had other statements that he made at the same time, correct?
Correct.
So I want you to walk me through those again in order. When you're going from the St. Petersburg Police Department to the Pinellas County Jail, what's the first thing that he says? And you can refer to your report and give us the answer.
The first statement he said, in reading the report, he stated that he stated that he did not throw his daughter into the water, but dropped her into the water. Well, that was his first statement, and then right after that, he stated that you do not know what I've been going through, was the second one, and then the last one is this the statement with the he was asking wanted to know what he did wrong.
And that was after he made the previous 2 statements, so he made that 3rd statement. Am I right?
Mm-hmm.
That's all I have.
Anything further?
Officer, I just want to clarify something. You just broke down those statements you said as the first, the second, and the last, right?
Yes.
Those were all after whatever he said about Michael, correct?
Yes.
When he told you to take him to Babylon, correct?
What's the objection?
Asked and answered.
Those 3 statements, the ones that you identified as the first, second, and last, those were all after he had said something about whatever he said about Michael at the scene that you didn't notate, correct?
Right.
When he asked you to take him to Babylon, correct?
Correct.
When he asked you to take him to the airport, correct?
Correct.
And when he told you the only way he will live is with him, correct?
Yes.
Nothing further.
Anything further?
There you go.
Okay. Anybody have questions for Officer Carter? No? Excused or standby?
Stand by.
So Officer Carter, thank you for your testimony. You're on standby.
Thank you.
State you may call your next witness.
Your Honor, at this time, the State of Florida rests.
Counsel approach, please.
No.
No.
There you go.
It's 11:55, Your Honor.
Yes.
All rise. Court being recessed. 11:55 according to the courtroom clock. All rise.
I'll be
Court
seated.
now back in session.
You want to make your JOA argument now? Okay. Yes.
Judge, do you want me to give you a heads up as to the content of the case?
Yes.
This is against my argument. So I'm just letting you know.
Yeah, I was wondering.
Yeah, the Supreme Court has ruled on the issue, but.
Okay.
As to the felony murder judge, well, we are, at this time, defense is moving for judgment of acquittal. Specifically, I'll start with first-degree murder under the felony murder theory. Judge, it is our contention that at this time, the state has failed to make a prima facie case of aggravated child abuse sufficient to sustain a conviction for felony murder. I understand this. I've provided the court with State v. Sturdivant, Sturdivant. That's 94 Southern 3rd 434, Florida Supreme Court case from 2012. That case overturned Brooks v. State. However, we are arguing that that should apply. The facts as we have them in here, there's a single act that constitutes the aggravated child abuse and also the murder. The Supreme Court basically held that the legislature's intent, they specifically included aggravated child abuse under the felony murder statute, and so that destroys any argument regarding the merger doctrine. We understand that it is not, it would not be sufficient for somebody to be charged with with felony murder based on the underlying felony of aggravated battery. And our position is a child abuse is the exact same in aggravated battery with the additional requirement of the age of the victim. And so we do not believe that aggravated child abuse, especially when we have facts such as this, whereas the only evidence is that there is one act of releasing the child off over the side of the bridge that caused her death, that should be sufficient for felony murder.
Okay.
As to the premeditation, Judge, at this time we are asking the court also to grant judgment of acquittal regarding premeditated murder in the light most favorable to the state. They have not adduced any evidence that the killing was with premeditation. We would agree that Phoebe is dead. However, in addition, the state has to prove that the killing was with premeditation, which is defined after is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. We have no evidence at all before the killing that Mr. Jonchuck had formed any kind of intent. In fact, quite the opposite. According to Officer Vickers, he indicated that he had a blank expression, didn't respond or to anything that was being said to him. The only statement stated was, "You have no free will," which would actually be contrary to some kind of intent. There's no evidence at all regarding whether at the moment Mr. Jonchuck released Phoebe over the edge of the bridge, he had formed any intent. And so we are asking the court that to grant judgment of acquittal as to premeditated murder.
Okay, I'm going to deny both those JOA arguments. Thank you for providing this case. State v. Sturdivant, Supreme Court, 94 Southern 3rd 434, which clearly stands for the proposition that aggravated child abuse can be an underlying felony for felony murder, and the murder doctrine doesn't apply. And as to the premeditation aspect, in the light most favorable to the state, after Mr. Jonchuck stopped his car, he got out, he was confronted with Officer Vickers. He made whatever statement he did, continued on, took his daughter out of the back seat, took her out of the booster seat, and dropped her over the Skyway, or over the Dick Misener Bridge. So that would be certainly enough time for premeditation to take place. And one could certainly, in the light most favorable to the state, find that the intent was there during that course of conduct. Do you have anything else you want to say? Okay. All right, you can call your first. Oh,
Actually, we do have another motion at this time.
Okay.
At this time, Judge, we'd be moving for mistrial. The state elicited a number of statements in opening statement of which they have introduced no evidence that served no purpose other than to try to prejudice the jury, and arguing that they would be able to prove their case for premeditated murder. They indicated that he went over to Noemi's house, that he had professed his love for her, that he was a man scorned and started his premeditation at that moment because he was so upset as to what had happened. Additionally, they elicited during opening statement testimony from Michelle Jonchuck, who they called to the stand and intentionally did not introduce the testimony of after stating it in opening. In opening, they indicated that Mr. Jonchuck had had an argument with his mother a few days before this, and at that time made the statement, and that he repeated it multiple times, quote, "I'm going to do something to fuck your life up," end quote. Highly prejudicial. There is no evidence at all. It was argued not as rebuttal as to how they would rebut any insanity. It was argued as to how they would prove premeditated murder, both of those. And so they have not introduced any evidence of such. There's no way to unring the bell. That evidence was intentionally not introduced in front of the jury after laying that out in opening, and we are moving for mistrial.
Response.
Your Honor, that was all said in anticipation of the evidence that is still going to come forward from this trial. The defense has already indicated that they're calling the mother and the father of the defendant to the stand. That evidence is going to come out. That was all in anticipation of the NGRI and the insanity arguments that were to come and that are still to come. They have a case that they're going to put on. We have a rebuttal case in which we're going to put on evidence and witnesses. So it was clear that I was arguing toward the insanity. That's why I made those arguments, and that evidence is still to come, Your Honor.
Okay, thank you. Motion denied. Okay, ready to have the jury back in? All right, let's bring them in, please.
Counsel and Deputy Rice. Line them up. Bring them in. in the jury box. Receive, Your Honor.
Thank you. You may call your first witness.
Yes, Your Honor, the defense would call Officer Andre Sousa.
Sir, if you would, stand right here for me, please. Face this clerk, raise your right hand, sir, take you.
You do solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Now, sir, if you would step over here, have a seat in the red chair. The mayor, loud and clear voice for the court. You go close to the mic, all right?
Good afternoon, Officer.
Good afternoon, ma'am.
May I proceed? Could you please state your name?
Officer Andre Sousa.
Okay. And what is your occupation?
I'm a patrol officer at the St. Petersburg Police Department.
How long have you been with the St. Pete Police Department?
Almost 5 years now.
Okay. And what is your current assignment?
Currently assigned to day shift uniform patrol.
Okay. And back in January of 2015, what was your assignment?
I was assigned to late evening shift of uniform patrol. It was 4 p.m. to 2 a.m. and I worked District 1, which is the south end of the city.
And were you working on the night of January 7th into January 8th of 2015?
Yes, I was.
At some point, as you were working that night, did you hear the call out about the bridge?
Yes, I did.
Okay. And where approximately were you in the city when you heard that call out?
I was down at about 58th Avenue South, 31st Street. I was there near the Wave condos. I was finishing up on a call.
Okay. And when you heard the dispatch about, or heard the call out to the Dick Misener Bridge, what did you do?
I responded and met with the other officers, or to the area where the officers were on top of the bridge.
Okay, so did that take you traveling down I-275?
Yes, I got on I-275 there at the Pinellas Point exit, which is the farthest south, or farthest southern entrance to the interstate there.
When you got to the scene at the top of the Dick Misener Bridge, were there already a number of officers present?
There were a few officers, yes.
Did you stop at the top of the bridge?
No, I did not.
And why not?
I continued to drive. I realized we had no one else that had gone to look for the suspect vehicle at this point, so I began driving south to try to find the vehicle.
Okay. And as you did that, did you go over the Skyway Bridge?
Yes, I did.
And did you go into Manatee County?
Yes, I did.
And at some point, did you have a description of the car that you were looking for?
Yes, I did. I had a description of the vehicle as well as the plate information.
Okay. And it's was the description of that car the white PT Cruiser?
Yes, it was.
Okay. And as you're traveling south on 275 and going towards Manatee County, did you see the suspect car?
Yes, I did.
Okay. And were you the first officer that made contact or saw the car again after it had left the bridge?
Yes, I was.
And what did you do once you put eyes on the white PT Cruiser?
At this point, I got on the radio. I gave out the tag of the vehicle I saw, which was confirmed immediately by the other officer and by dispatch that it was the correct vehicle. I announced where I was, and I announced that I was going to be just keeping surveillance on the vehicle until another officer could get there.
Okay, and so obviously you had gotten up close enough to the car to read the tag number?
Yes, I did.
Okay. And what lane were you traveling in on 275?
We were in the right lane.
When you say does that mean the PT Cruiser was also in that right lane?
Yes, the PT Cruiser was directly in front of me.
Okay. And the right lane, well, I'll move on. We know what the right lane is. And approximately how fast were you traveling?
We're doing about 70 miles per hour.
All right. And at 70 miles per hour, were you keeping pace with the vehicle?
Yes, I was.
Okay. At the point when you initially observed the vehicle and you're doing the surveillance, Was there any sort of careless or unusual driving going on?
Not initially, no.
Did you have your lights and sirens on at this point?
No, I did not.
Why not?
At this point, I was still waiting for another officer there. I didn't want to conduct a stop until I had a backup officer there with me.
Okay. As you're traveling down 275, do you eventually approach the exit for I-75?
Yes, we did.
Okay. And does the white PT Cruiser do something at the approach to I-75?
Yes.
And what happened?
At this point, he takes the ramp that takes him northbound on 75 towards Hillsborough County. At that point, there's a large semi-truck up ahead. The ramp is a single lane. At this point, I thought I was not seen by him. So at this point, he begins to pass that semi-truck on the emergency lane. He accelerates and passes the semi-truck on the left in the emergency lane, taking evasive movement to get around him there.
Okay, and so that happened on the on-ramp to 75 northbound?
Correct.
He goes around the semi in the emergency?
Yes.
Okay. And I think you just said this, but did you have your lights and sirens on yet at that point?
No, I did not.
All right. Did you follow him, follow the white PT Cruiser onto I-75 northbound?
Yes, I did.
And what lane were you in?
We're in the right lane.
And approximately what speed were you going?
About 70 miles an hour.
At this point, did you have any backup units right there with you yet?
Not immediately there. I knew I had one coming.
Okay, and would that have been Officer Gillis?
Yes, it was.
Okay. But she's not close enough to you yet at this point where you think it's appropriate to try to do the stop?
Correct.
As you are traveling northbound on I-75 following the PT Cruiser, do you eventually start to approach the Moccasin Wallow area?
Yes, we do.
And does the car do something, the white PT Cruiser do something unusual at that point?
Yes.
What happened?
At that point, the PT Cruiser starts to slow. He turns his right blinker on, and he starts moving to the right towards the emergency lane. He slows down to about 10 miles an hour, almost coming to a stop. At this point, I announce over the radio that it looks like he's going to stop based on where he's pulling off the road onto the emergency lane. And at that point, that's when I activate my emergency lights and siren.
Okay, so just to walk that through step by step, you see the car start to slow down.
Correct.
You see the car put its right blinker on.
Yes.
You see the car down to about 10 miles an hour, almost to a stop.
Yes.
The car goes into the right emergency lane.
Yes.
And it's only at that point that you then put your lights and sirens on.
Yes.
Okay. And after the car does the blinker over into the right, what does the car then do?
At that point, the vehicle switches its blinker to a left blinker and makes a left turn. It makes a U-turn directly in front of my cruiser, almost around the front of my car, and begins traveling the wrong way on Interstate 75.
Okay. So we go from right blinker to left blinker.
Correct.
And your lights and sirens are on.
Yes.
At the point he actually makes the turn.
Yes.
What do you do when the PT Cruiser starts traveling southbound in the northbound lanes of 75?
At this point, I announced that he's now driving the wrong way. I knew I had another officer coming. As soon as he passes across in front of me and I realize that he's not stopping there, that he's going to continue, I make a U-turn with him there to continue to try to stop him.
And did you see a backup officer approaching at that point?
Yes, that's when I see Officer Gillis's lights coming northbound on 75 towards us.
And Officer Gillis put her lights and sirens on as well?
Yes.
And then does Officer Gillis also make a U-turn? Well, let me back up. After the white PT Cruiser makes the U-turn, does Officer Gillis have to do anything as the PT Cruiser approaches her?
Yes, as the PT Cruiser approaches, I can see her lights coming. I see the PT Cruiser veer into her path. And at that point, she takes evasive action and veers out of the way of the vehicle as we both pass it before she makes a U-turn.
And so then after all three of you make the U-turn, then it's the PT Cruiser traveling southbound, and then are you the next car behind him?
Yes, I'm vehicle one, the first vehicle in the pursuit behind him.
And then Officer Gillis is behind you?
Yes.
Were you able to continue the pursuit southbound in the northbound lanes?
Yes, at that point we continue the pursuit south based on the charges we had and the fact that there was no immediate place to exit the lanes of travel we were in. We followed behind in the right lane.
And when you were able to, did you then exit off of the northbound lanes to get over into the southbound lanes?
Yes, we did.
And when you did that, did you lose sight of the PT Cruiser for a period of time?
Yes, we did.
And as you then are traveling southbound, is Officer Gillis still behind you?
Yes, she was.
And do you still have your lights and sirens on?
Yes.
As does she?
Yes.
And are you able to accelerate and get down and catch up to the car again?
Yeah, once we exited, we got back on into the right lanes, the southbound lanes of 75, and we were able to catch up and reacquire his vehicle.
And then at that point, are you paralleling him basically?
Yes, we are.
He's southbound in the northbound lanes, you're southbound in the southbound lanes.
Correct.
As you begin to approach down towards the university exit in Manatee, what did you see going on?
At that point, I see looked like a wall of lights across the northbound lanes there. Based on what I saw, it looked like they had a roadblock set up. I didn't have communication with them, but based on what I saw, that's what it looked like, was a roadblock.
Okay, and when you say you didn't have communication with them, are you talking about the other agencies at that point?
Yes, I'm talking about the other agencies that were involved. At that point, we didn't have direct radio communications with them.
Okay. Can you estimate how many police cars you saw out there in that area?
There were several. If I had to take a guess, it'd be at least a dozen.
Did the white PT Cruiser come to a stop before reaching the actual barricade?
Yes, it did.
And what do you do at the point that the PT Cruiser came to a stop?
At this point, I pull my vehicle up to the median, into the grass there in the median. I exit my vehicle, jump over the median there, and begin running towards the suspect vehicle.
Were any of the other officers already out of their vehicles and approaching the PT Cruiser by the time you were approaching?
Yes, there were some officers from one of those other agencies that were already approaching.
Did other officers have their firearms drawn?
Yes, I did.
So you and Officer Gillis, did you join the other officers that were there surrounding the car?
At this point, that's when I approached. Like I said, we didn't join them. I didn't have communication with them. I could just see that they were yelling commands to him.
Okay. And what sort of commands were being yelled out?
I could hear "show me your hands" and just other commands I can't specifically remember.
And when I said join them, you actually go up to the vehicle itself, right?
Yes, at this point I decide there's officers already covering with their weapons out. At this point I decided I'd be the one that would attempt to go hands-on and make the arrest.
And by hands-on you mean what?
Means I have my hands clear. I can do what needs to be done if I need to open the door, if I need to break a window, or if I need to actually be the one that places them in handcuffs.
Okay. As you and the other officers are surrounding the PT Cruiser, some with their firearms out, were you able to see into the car?
We were, but it was a little distorted from the lights and things like that.
Okay. Could you see where the driver's hands were?
Yes, I could.
Where were they?
They were on the steering wheel.
Could you see where the person's, face was looking?
Yes.
And where was the person looking?
Straight forward.
Did you hear the driver say anything?
No, I did not.
Did you see him reach for anything?
No, I did not.
as people are yelling and the commands are being given, was he doing anything other than hands on steering wheel, staring straight ahead?
No, it was not.
When you mentioned that you tried to go hands-on, what did you try to do to get into the vehicle?
Initially, I tried to open the door, saw the door was locked. At that point, that's when I utilized my baton and first broke out the driver window and the front driver window, and then the rear left window.
And as you're using the baton to break out the windows, I would imagine glass is going everywhere?
Correct.
What does the driver do?
Stays in the same position, hands on the steering wheel, looking forward.
Not saying anything or responding to what's going on around him?
No.
Were you and the other officers continuing to give him commands?
Yes, we were.
And did he respond to those commands?
No, he did not.
Did you have to physically do something to get the driver out of the vehicle?
Yes, we did.
What did you have to do?
At that point, I was able to get a hold of his left arm there, wrist and arm. We had to physically remove him through the window once we were able to get the seatbelt off of him.
Okay. As he's brought out the window, is he taken down to the ground?
Yes, he is.
And is he, while you're getting him out the window and out of the car, is he actively resisting you in any way?
No, he's not.
He's just not complying?
He's just not complying, not doing anything.
Okay. When he is down on the ground, and I assume he's getting handcuffed behind his back?
Yes.
Okay. Was he resisting getting handcuffed behind his back?
No, not actively.
Okay. Just not complying with your
Just not complying. We were having to do everything ourselves.
And after he was handcuffed, was he walked over to one of the police cruisers?
Yes, he was.
And as he is being walked over to one of the police cars, did he do anything like try to break free or run or anything like that?
No, he did not.
Okay. May I have one moment, Your Honor? Just a couple more questions, officer. In the process of taking Mr. Jonchuck out of his vehicle, cuffing him and taking him over to the police cruiser, did you at any point hear him say anything?
No, I did not.
Okay. And while, when you picked up the PT Cruiser initially on 275, we think we talked about he was going about 70 miles an hour?
Correct.
Okay. And then we had sort of the strange driving on the ramp to 75 north. And then when he started going northbound on 75, on I-75, was his speed still at about the 70 miles an hour?
Yes, it was.
Until the U-turn, right?
Correct.
And then when he started going southbound in the northbound lanes of I-75, it was still about 70 miles an hour.
It varied a little bit higher there, but it varied.
Okay. May I ask the witness to step down for just a moment? Let me show you what's in evidence as State's Exhibit 8. I just want to clarify with you. 275, right?
Yes.
And this is coming from the Skyway?
Yes.
Over there?
Correct.
Okay. So at the, where 275 meets up with 75, you can either go north towards Hillsborough or south towards Manatee, is that right?
Correct.
Okay. And the PT Cruiser went up north towards Hillsborough?
Yes, it did.
Okay. And then eventually up, right up here around Moccasin Wallow, that's where you start going southbound again,
Yes,
is
it
that
is.
right? Okay, may I have one more moment, Your Honor? Thank you. No further questions.
Ross?
When you got behind the defendant and he started going up the ramp to go to 275, now this ramp is pretty high, right?
Yes, it is.
And there was a semi-truck, tractor-trailer truck in front of the two of you.
Correct.
How far behind are you from him at that moment?
At this point, I was maybe 5 car lengths. I was trying to stay back.
But close enough to read his tag?
Yes, I came up on it first, yes.
Okay. And then he speeds up to go around that semi-tractor trailer, right?
Yes, he does.
It's only one lane going up there.
Correct.
So he's squeezing by in an emergency lane to get by.
Yes.
So you do the same activity?
Yeah, so this with the semi-truck, he sees what's happening and he kind of moves a little bit to the right, which actually gave me more room to get around him.
Then he starts heading north on 75.
Yes.
And starts to slow down and pulls into the emergency lane on the right.
Correct.
And you're wondering, is he thinking about what to do next, right?
Yes.
So you think he's contemplating, what should I do?
Objection, relevance, and speculation.
Oh.
Correct?
Correct.
Okay. And then he makes a U-turn.
Yes.
And when he makes that U-turn, he drives aggressively at Officer Gillis, right?
Yes, he does.
Causing Officer Gillis to take evasive action to get out of the way.
Correct.
Now, Officer Gillis had her lights and sirens on.
Yes.
So he would have known she was a police officer.
Correct.
And when he made this turn, he wasn't looking at you, was he?
No, he was not.
He was paying attention to how he made this turn.
Yes.
Okay. And then he accelerates.
Correct.
Up to 75 miles an hour.
Correct.
And then later up to 80 or 90 miles an hour.
Correct.
And then eventually he gets stop sticked, right?
I didn't see directly, but that's what I was informed later.
Okay. So you didn't see the stop stick?
No, I did not.
When did you learn that he had been stop stick?
I believe it was later that night.
Okay, so you didn't know it when you went to put hands on him?
No, I didn't know when the vehicle came to a stop, no.
But he had been stop sticked?
Correct.
So that means his tires are flatted?
Yes.
And there's a barricade?
Correct.
Of cars?
Yes.
He couldn't go anywhere?
No.
So when he stops, he's got nowhere to go?
Correct.
And he's told to keep his hands where he can see them?
Correct.
And they stayed on the steering wheel?
Yes.
But any other command, he didn't follow?
Correct. He didn't obey any other command or exit the vehicle or anything.
And Moncha? Nothing further.
Anything further?
Just a moment, Your Honor. Sure. Nothing further, Your Honor.
Okay. Any questions for Officer Souza from anyone? No? Can he be excused, defense?
Yes, Your Honor.
State?
Yes.
You're excused. Thank you for your testimony, Officer Souza. Okay, it's time for lunch. 12:35, we'll reconvene at 1:30. Please don't discuss the case. Any questions? Okay, thank you very much.
Jury's out of there in the courtroom.
Anything you need to talk about?
Judge, we have, this afternoon, we have an additional 3 witnesses, and that's all we are able to call today.
You need to get more in here. Don't have the time to do it this way.
Judge, I understand, but my client's entitled to a fair trial.
I understand.
And the courts keep telling us we have to go faster. We're going as fast as we can, Judge.
I've given everybody the opportunity to take the breaks, to do what they need to do. I'm in charge of making sure it's orderly and efficient and that we get done as soon as possible, yes, but not forsaking his right to a fair trial. Yesterday I said, you're gonna need to have 5 hours of witnesses here because it was, I foresaw it yesterday. The state said they could be done by 11. I don't think they were done till, I guess, almost noon. That's what I said. I'm not gonna stop the trial early because you haven't gotten your witnesses here. You gotta take them out of order. You gotta get somebody here to testify.
Judge, we'll call it in. I mean,
Okay.
that's all we can do. But
I understand.
I mean, we have a witness under subpoena that's refusing to come in, so we
Well,
can't
I'll
call
do
it.
what I need to do to get the person here. Do you want me to do something to get the person here?
Well, what we would suggest, and I'll let the state know, it's Elaine Vendrone, who was the person that called in and suggested to him that she saw the car go through the red light at 100 miles an hour. They went and found a red light camera that would verify that. So I have Detective Harper here. He's the one that talked to her. If the court allows me to bring in hearsay testimony from him, then we don't need to call Elaine Vendrone. I can get that information for the jury.
Mr. Ellis?
We're not agreeing to that.
Okay. So you're gonna need to, is she on the witness list? Is it
She
he?
is.
She?
She is on the witness list. She's been subpoenaed. She was contacted by victim witness today, and she has refused to come in.
Okay. Do you want to bring me a motion for order to show cause? I'll have her served this afternoon, and maybe she'll change her mind.
Judge, I'd be happy to do that, but I can't because I've got to go try to find other witnesses to bring in.
Well, maybe somebody else can do it.
Judge, the issue we're having, why we have these witnesses, every day we've broken after victim witness is gone. So we're going down there, excuse me, yes, like last night exactly, about, it's like 7 o'clock. We're trying to get in contact with witnesses. We don't have cell phones for them. It's after hours, and we can't get cell phones from them from victim witness, so they're closed. So we're going down first thing in the morning and saying, get us who you can get us. But we've spoken to a couple witnesses due to availability. They're not available until tomorrow, and so I don't know who on the list we're thinking we could get. And that's and unfortunately, with all the witnesses and the length of the trial, we've had to, I mean, there's nobody that's just said, okay, I have blanket availability for the next 3-4 weeks, you guys call me whenever. And so the court had indicated, obviously, a willingness to work with us based on who we were able to get in and put them on. And I think you even said if we have to break early some days because we're out of witnesses, that's fine.
I did. However, yesterday. It's not like an unexpected event. No one said, I asked Ms. McNeil, can you get people in for 5 hours? Yes, I can. Mr. Ellis represented at the beginning of the case, the state was gonna call a dozen witnesses, so it was gonna take 2 days, and they'd be done. It's 2.5, and they've called a few more. So it's not like people weren't on notice. Ms. McNeil didn't say to me, oh, we can't do that. We only have 3 witnesses.
Well,
Nobody said, whoa.
We didn't know at the
Miss
time, Judge.
Manuel, don't interrupt me. Nobody said we only have this. She said, yeah, we got plenty of witnesses. So to me, how many witnesses do you have? How many witnesses are you about going to call for your case? Ballpark figure.
While they're counting, Judge, just so yesterday we had no chance to attempt to get any witnesses together. Over lunch we did a deposition. We had 20 minutes to get back to the office, shove some food in our face, get back up here. On the breaks, we can't have meaningful discussion because the courtroom is mic'd. We can't go back down to our office over 15 minutes because as soon as we get down, we come back up, we're starting again. So we can't call witnesses on breaks. The only time we're able to reach out to those witnesses is when we break for the day.
Well, the back room is not mic'd. The conference room back there is not mic'd. So how many witnesses do you think you'll be calling for the defense during the course of the defense? Not exactly, but approximately.
Well, that's counting everybody.
About 17, Your Honor.
It's not that many, actually. So other than the 3 people that are lined up, is there anyone else in that? How long will the 3 people take?
I would say less than 3 hours.
Okay, so then we're at 3:30 or 4 o'clock. Is there anyone else on that list? The other 14 that you could get in and put on at 3:30 or 4 o'clock? Because we're wasting hours that we have.
Our case would not make sense. We would like to not have to call them out of order, but we can try to find somebody if the court's ordering us to.
I'm not ordering you to do that. I'm expressing my displeasure at time that you knew you had to fill yesterday. That's why I went through this exercise.
And if I could just respond, one of the witnesses we want to call is sick and so can't come in. The other witness, Ms. Torres, is the attorney, and due to scheduling issues, we spoke to her last night. Thursday morning is when she can come in. So it's not that we have everybody lined up to go Thursday. We just have a break today because Torres couldn't come in and the other witness is sick. And now we're having Ms. Vendrone refuse to come in, but that's...
Well, you need to bring me in order to show cause, otherwise I'm not going to be very empathetic about the whole thing.
Right.
Additionally, when you talk about having a fair trial, one of the aspects for a fair trial is for the jury not to be exasperated and angry because they're giving us the time and then we quit early. And that usually inures to the side against where we're hearing the witnesses. I'm obviously not going to say anything, but when you talk about having a fair trial, part of that is their perception that people are being considerate. So with that said, I guess you do what you can do. I'm not going to order you to do anything differently. I just am disappointed that we cannot use the time. Anything else?
Okay. All rise. We'll be in recess till 13:30 according to the courtroom clock.
They make us do it because they don't want to pay us. But yeah, I come in and everyone's already gone to work. And then my lunch break, I never see anyone.
That's so funny.
There's a fancy word for that, right? It's called spectators. You can't spell it, right? Yeah, we know that.
Hey, Jocelyn.
Don't you guys rest?
Ah, look
I
at you.
figure I might as well do all this.
You have to buy another box of these, huh?
They don't want to just wait till the end.
You know, I looked at it. There's 8 of them, so I'm not gonna try and find out who the 8 are or what.
Yeah, it's not like they're going in every day after we get out of here and get them to their managers.
Can we just do this right? No, 8 jobs.
I do. Take your phone.
I've got another camera.
But still, like,
You can tell them that.
even if your manager would trust you, and be like, hey, I'm in trial, like.
And see them.
I'm trying, it's gonna be.
I have a story, so you're talking about Phoebe Jonchuck.
Oh. I never served.
You haven't gotten a cert or something?
Come on, you don't wanna get.
I don't mind doing Wednesday, or but I don't want to do it all day.
They picked my mom. He was like, you know, I don't think I can believe the testimony in the house, especially a lockout. Then they picked him anyways, and I'm like, well, that's random.
I'm not saying I'm gonna try and get out of it, I'm saying, look, I've been doing this for 13 years, or like 16, I'll be here tomorrow, 16 years, I've been. I've heard of them, I've heard of them.
You know, it was on the background.
Jury, so.
I forgot my girl back here.
Because I can tell you what, I didn't
You're gonna be like twisting everyone's arms, doing the other
They'll be fine. I told them I was home.
Defense, do you guys have anything you want, Mark?
Yeah, probably.
All rise. Circuit Court's now back in session. You may be seated.
Anything we need to address? No? No? Okay.
Good.
Okay.
Missing one.
What's it number?
go ahead and dump their stuff and line them up, bring them in. Cell phones off, correct? All right. Not, double check them. Jury's in a jury box and seated, Your Honor.
Thank you. Can you call your next witness?
Mr. Williams, just a second.
Mr. Williams, who is the next witness?
Judge, the next witness is Teresa Hubble.
Hey, ma'am, if you would. Stand right here for me, please. Face this clerk, raise your right hand, prayer to take the oath.
You do solemnly swear to affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
And ma'am, if you would, have a seat in the red chair. speak in a loud and clear voice for the court. Make sure you move up close to the mic.
Good afternoon.
And good afternoon. Can you tell us your name, please?
It's Teresa Hubble.
Can you, well, I guess you should spell your first name for us, just to make sure.
Teresa, T-H-E-R-E-S-A.
And your last name?
Hubble, H-U-B-B-L-E.
Okay. Are you employed?
I'm retired.
Congratulations. What are you retired from?
From St. Petersburg Police Department.
How long did you work for them?
I worked there 28 and a half years.
Can you advise the jury what training you had in order to perform your duties at the St. Petersburg Police Department?
I went to the police academy and I worked in numerous divisions throughout the department while I was there. When I retired, I was a police sergeant.
And were you a sergeant in January 8th, 2015?
Yes.
I don't know if this is the right way to say it, but what kind of sergeant were you, or what were you the sergeant of?
At that point in time, I was in charge of it was an investigative special unit. It was part of the detective division, where we would go out and pick up people that were wanted that had probable cause or needed to be interviewed by detectives.
And were you ever a sergeant in the patrol division?
Yes.
Can you tell the jury what a patrol officer does?
Patrol officer basically responds to 911 calls or any type of call that's called into the communication center, and then it's sent out to them, and then they respond to it.
Would they respond to calls of like bar fights and burglaries?
Bar fights, burglaries.
Road rage?
Community problems.
Traffic stops,
yes.
DUIs?
You name it, they respond to it.
And then a sergeant is in charge of those officers?
Yes.
Okay. And that's what you...
Basically, the sergeant's in charge of making sure they're responding to calls, they're investigating the calls, if there's any complaints about the calls. The supervisor will sometimes go to the calls as well, depending on if more officers are needed or if you're requested.
And you work your way up to patrol sergeant through patrol, is that right?
Yes, you do.
Okay. Going back to January 8th of 2015, how did you first become aware of this case?
I heard it go out over the radio that an officer was out with a vehicle on the bridge.
Where were you at that time, do you remember?
I was driving around in the cruiser. I want to say I was probably close to downtown area.
And what did you do when you heard that call?
I started immediately heading that way.
And by that way, you mean
towards the Skyway Bridge.
Okay. When you say heading, did you meander that way or quickly?
I quickly responded. I got onto the interstate and then went lights and siren.
And so that's the indication of how much of a hurry you were in. Lights and sirens means you're going as quick as you safely can.
Yes.
Where did you go?
Over the Skyway, as they were called. First, the first officer saw what he thought was a gentleman throwing a child over the bridge. Then another officer called out on the radio that they were behind the vehicle that was described. So at that point in time, we were responding towards where the officer was behind the vehicle. So at that point, they were already across the Skyway. So I was.
So while you're going toward the Skyway, you're hearing the other officers. You're getting updated through the radio.
Yes.
All right. So why didn't you stop on top of the Dick Misener Bridge?
Because they were still voicing out that they were behind the vehicle. It had not been stopped yet.
And is that's why you went
Kept
toward the vehicle?
continuing on, yes.
Okay. Still lights and siren?
Yes.
Where did you end up? Where did you go?
Somewhere off the interstate in Manatee County. I'm not very good at that area, so it was close to 301, that vicinity up in that area, Manatee County.
And again, you were going in that, you were listening to the radio.
I was listening to where they
you.
said they were, and as you approached, you could see the lights, and then I knew that I was in the right area.
When you arrived at and when you say the lights, you mean
From cruisers, yes.
a lot of lights?
Yes.
And what the lights that you saw, was that the roadblock that had been set up by Manatee?
Yes.
When you got there, were there already St. Petersburg Police patrol officers there?
Yes, there were.
To your knowledge, were you the first sergeant that arrived?
I don't think so, but I'm not positive.
All right.
I'm pretty sure there was another sergeant there.
What did you do when you got there?
When I got there, due to the exigent circumstances, I asked where the defendant was, and I was told he was in the back of Officer Carter's cruiser. And the main focus was trying to figure out who or what he had thrown over the bridge. So I found the cruiser that he was in, and I got into the cruiser with him.
Okay. Let me go back then and make sure, when you got to the scene, Mr. Jonchuck was already in a police cruiser?
Yes, he was. He had already been placed in a police cruiser.
And whose cruiser was it?
Officer Carter.
Okay. And that's a
St. Petersburg police officer.
Right, and his car is a full-on patrol car, not a low profile or anything like that? Lights, light bar, cage, everything?
Yes.
Before you talked to Mr. Jonchuck, were you able to see him?
Yes.
Were you able to hear him?
He was saying he was yelling. He appeared very agitated.
Was anybody in the car?
No.
So he is alone in the car?
Actually, I'm sorry, take that back. I want to say Officer Carter was sitting in the cruiser with him. Because I think I had him get out so that I could get into the cruiser to talk to him.
Okay. And your purpose of going over there was to, you said because of the exigent circumstances, it was to ask him some questions about who or what he had thrown over the bridge?
Correct. Because they were doing a search and rescue on the water as well. At that point in time, it was all kind of unfolding at the same time.
Were you in uniform?
Yes.
Okay. I know the uniforms have changed since then, but we've seen a number of officers come in today. I mean, you're in a full St. Petersburg Police Department uniform?
Yes. And as a supervisor, I had different gold stripes on my uniform.
Patches on your sleeves?
Yes.
Badge on your chest?
Yes. There's no way you could not tell I was a police officer.
Did you tell him who you were?
Yes, I got into the cruiser. He was in the back seat. I introduced myself. I go by Terry. Teresa's my given name, but I introduced myself as Terry. I introduced myself as Sergeant Terry Hubble and asked him what his name was.
What did he say?
He proceeded to tell me that he was God and that I needed to address him as such. And then he said my name, Terry, you need to take me to the city of Babylon.
When you got in the car, he was agitated and yelling?
Yes.
When you introduced yourself, did he stop talking or did he keep on yelling?
He would, when I was talking and introducing myself and asking a question, he would listen. And then he would yell an answer back to me.
Were his answers responsive to your questions?
Basically, I was asking him his name and who he had thrown over the bridge. He would never give me his given name. He basically would tell me that he was God or the fallen angel of Michael. And he would say, Terry, you need to take me to the city of Babylon. He would not tell me who he threw over the bridge, and he would not give me his name.
How many times did he tell you that he was God?
Numerous times.
How many times did he tell you that he was the fallen angel Michael?
Numerous times.
How many times did he tell you to take him to the city of Babylon now?
Numerous.
Was throughout your, I hate to call it a conversation, but throughout your interaction with him, did he make other incoherent statements?
It was basically him repeating the same thing. He actually was asking for his Bible, which I got on the radio and was asking the officers that were near the vehicle if they could see a Bible, because I really didn't know what he was talking about. And he was very adamant about his Bible and wanted to know if his Bible was okay. So I asked the officers, and one of the officers, Officer Julie Bryan, had said that she saw the Bible in the front seat of the car.
Okay, let me back up a little bit there. How many times did he ask for the Bible?
Numerous times.
Okay. Was this after he'd told you that he was God or the fallen angel Michael?
Yes.
Okay. Did he ever go back and forth between those two?
Between God and the fallen angel of Michael?
Yes.
Yes.
And did he ever go back and forth between where's my Bible or how's my Bible doing and I am God?
Yeah, when I would ask his name was when he would typically say he was God and the fallen angel of Michael, and then intermittently between all of continually saying that, he would say, I need my Bible. Where's my Bible? Is my Bible okay?
Did you ever have a chance to see this Bible that he was talking about?
I did not see it out at the scene, but when he was transported to Manatee Sheriff's Department, I didn't look in it, I just saw it. It was a big, thick book that he considered his Bible.
I'm going to try to save some time instead of showing you what's previously been marked. The Bible, you said it was big, thick?
Yes.
Brown, dark colored?
Brown color.
Looked old?
Yes.
So we know what we were talking about. Thank you. And you said it was Officer Bryant that checked the vehicle or checked his car to find it in there?
Yes.
Okay, and then you saw it back at the
when we were at Manatee Sheriff's Office.
Okay.
I told him while I was talking to him, because he kept asking about it, that we would take it with us, so that to try and let him know, okay, we have the Bible and we're going to take it with us. We're taking you to Manatee Sheriff's Office.
Yeah, how did that come about? Going to Manatee instead of going to St. Pete?
Because it was closer, and then we were waiting for the detectives to arrive. Therefore, it was a place to get off of the middle of the interstate. And it was probably like 10 minutes from where we were at.
I guess I didn't really think about that. These conversations that you're talking about, or again, the interaction you had with them, this is on I-75?
Yes.
And still all the lights and sirens and everything's going on?
Yes.
Okay.
We were in the median of the interstate.
And who transported him back to Manatee?
Officer Carter and Officer Bryan.
Okay. You went into the station with them?
Yes.
And where was he?
He was placed in an interview room that they have that had audio and video.
And I know that you wouldn't have been in charge of that, but I mean, the idea behind that interview room is to record whatever happens in that room?
Well, it was a place for us to wait for the detectives so that they could come and interview him, and they happened to have one that was audio and recorded.
Okay. And you were aware of that night? I mean...
Yes.
Okay. At the time that he's in the Manatee County Sheriff's Office station, I guess we could call it. Is he in your custody or their custody or everybody's custody?
Basically in our, Officer Carter and Manatee, there were detectives from Manatee that were there as well because they had to let us into the building, and that they were there when the traffic stop occurred.
Yeah, and
So.
Oh, keep going, I'm sorry.
No, I'm trying, he basically was in our custody, waiting for the detectives.
Yeah, and let me clear that up, but I guess what I should have done a better job of saying is he was there and it was Officer, as opposed to you, it was Officer Carter that was responsible to keep an eye on him?
Right. Officer Carter, and I want to say it was Manatee Sheriff's Office, Officer Huff.
Yes, ma'am. Did you watch the audio and video feed while he was in that room?
I could go and look at it if I needed to, but for the most part, we were trying to get information on who he was and who was in the car with him and who he threw over the bridge.
So it was available to you, but it wasn't your job to sit there and monitor it?
No. At one point in time, I think he asked for me, and I went in and explained to him that we were waiting for the detectives to get there to interview him. He was given water and asked if he needed to go to the bathroom or anything.
Were you there, or were you either right outside the room or watching on TV or anything, or the feed, when he called for you?
He called, I was walking by, and then I think he asked Officer Carter if Terry could come back in or something and talk to him. So I went in and I explained to him again that the reason he was there, the time that it was taking so long, we were waiting for the detectives to come.
Judge, if I could have a moment. Just a couple other things I wanted to ask you. Did he ever tell you why he needed to go to Babylon?
No.
The Bible that you described to us, the large, dark-colored, old, did you ever hear it making any noises?
No.
Did you ever hear it knocking?
No.
Did he appear to be under the influence of alcohol?
No.
Did he appear to be exhibiting any symptoms of a drug overdose or drug usage?
No. He was just very agitated. He was agitated in the car. Once we got to the sheriff's office, he had calmed down a lot.
But he wasn't drunk?
No.
Wasn't high?
No. To my knowledge, no.
That's all I have, Judge.
Ross?
Yes, sir. Afternoon.
Hi.
Should I still call you Sergeant?
No.
So when the defendant was talking to you and he was telling you some of the statements that Mr. Williams just asked you about, he never said anything about escaping an ice age, did he?
No.
Okay. You'd remember that if he had said that, correct?
Yes.
He didn't say anything about hearing demons talking to him, right?
No.
Didn't tell you that he heard voices, did he?
No.
Okay. He didn't tell you that he heard voices that told him that he and Phoebe both had to die, right?
No.
Never heard any of those statements.
No.
He never told you that if he and Phoebe didn't die, that...
Judge, maybe approach? Yes.
Yes. Is Ms. Hubble on standby?
Yes, Your Honor.
Thank you, Your Honor.
Thank you.
Can you call your next witness?
Your Honor, may I approach briefly with the state?
Yes. Gentlemen, we're going to need to take about a 10-minute recess. Thank you. Keep your heads on the chairs.
Out of the hearing, court, Your Honor. All rise. We'll be in recess for 10 minutes according to the courtroom clock.
So I don't know if she wants it up before the witness takes a stand or what. All right. So I'm gonna just get it plugged in. And then you leave it where we need to.
Probably, but not in my head. You're gonna come back. Okay, yeah.
No,
You're not leaving us in charge of this.
She wanted it set up.
Yeah. I just want to know where she wants it.
Before we talk, I got something I gotta ask you. Because I touched it, I'm like, dang it. I didn't know what it was. Right. Actually, I went to lift it up to see what it says on it. I said, nothing like that. No, it's legit. Okay.
Where do you want the TV?
In front of the jury?
That's fine. If you're ready for it to be there already.
Let's just do it, yeah. She's only gonna talk to the music. And then when I asked to publish, just gonna have you play it.
That's fine.
God, that's sweet.
That's what I'm here for. turned off, just in case.
Will the clips play one at a time?
They play side by side together. You can play twice. So they're timed together.
Yep.
Make sure we have that way this one. Why it's not coming up. There we go. Mute. Just like that. Until you say play. And then left. Okay. It's 26 seconds long. Sure. Come on up. Plus, I've got things connected to it.
Was that anti-person?
That would be it.
Yeah.
This one is coming from
Yeah,
there.
and you see this one. They're two different angles.
Either one of us.
Yeah.
Council, you ready?
Yes.
All rise. Court is now back in session. You vote.
Ready?
Yes, sir. Thank you.
Bring him back. Ready? Jocelyn, Deputy Reich, line him up, bring him in. the jury box and seated, Your Honor.
Can you call your next witness?
Defense calls Elaine Vendrome.
Ma'am, if you would step all the way over here for me, please. And you stand right here, face this clerk, raise your right hand. Where to go?
You do solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And then, ma'am, if you would step over here carefully. Have a seat in the red chair. Speak in a loud and clear voice. Make sure you move up close to the mic.
Good afternoon, Ms. Vendrome.
Could you please state your full name?
Elaine Vendrome.
And could you spell your last name, please?
V-E-N-D-R-O-N-E.
Okay. What county do you live in, Ms. Vendrome?
Hillsborough.
Did you live there in January of 2015?
Yes.
Okay. On the night of January 7th into January 18th, January 7th into January 8th of 2015, did you happen to be out driving?
Yes.
Okay. And as you were driving, did you come to the intersection of West Kennedy Boulevard and West Shore Boulevard?
Yes.
Okay. And approximately where is that in Tampa?
Yes.
Approximately where in Tampa is that?
Near West Shore Mall.
Okay. And is it close to where 275 turns into the Howard Franklin to go to Pinellas County?
Yes.
Okay. Were you in the area of that intersection, West Kennedy and West Shore, sometime between 11:50 p.m. and midnight on the night of January 7th?
Yes.
As you were as you were approaching that intersection, did you happen to notice a white PT Cruiser?
Yes.
And did you notice something unusual happen with that white PT Cruiser at the intersection of West Shore and West Kennedy?
Yes.
What did the white PT Cruiser do?
He ran through the red light.
Did it nearly cause an accident?
Yes.
Or more? Did you, after hearing the events of what happened on the Dick Misener Bridge that night, did you recognize that a white PT Cruiser had been involved?
Yes.
Did you let law enforcement know what you had seen that night?
Yes.
Okay. May I approach the clerk and the witness?
Yes.
When that white PT Cruiser entered the intersection, was it going fast?
In my opinion, it was fast. I don't know how fast it was going.
Okay. I'm sorry, may I approach the witness?
Sure.
I'm showing you what's been marked Defense Exhibit 5 for identification. Do you recognize that?
Yes.
And what is that?
A DVD.
Okay. And do you recognize your initials on it?
Yes.
Have you had a chance to review what is on this DVD?
Yes.
And is it a view of what you saw at the intersection that night?
Yes.
Would ask to introduce what's been marked as Defense Exhibit 5 as Defense Exhibit 5.
Any objection?
There.
Let me see.
And may we publish to the jury? And may I have the witness step down towards the TV? And I'm going to direct your attention to the left side of the screen first. Was the white PT Cruiser we just saw come this direction, is that what you saw that night?
Yes.
Okay. Now if we could play it again and look at this viewpoint or this angle. And can we pause it for just a second? Are you back here on the road approaching this way?
Yes.
All right. And does the white PT Cruiser pass you?
Yes.
Okay, so you're behind him at the point of the cruiser going through the intersection?
Yes.
Okay, could you restart it? Okay, and is that what you saw that night?
Yes.
Okay. I'm sorry, you can take your seat back again. Ms. Ventrum, one last question. When you spoke with the officer telling him what you saw that night, do you recall telling him that you thought the vehicle was going about 100 miles an hour?
I don't recall.
Okay, that's all I have.
Cross? Nothing. Can this witness be excused?
Yes, Your Honor.
Excused?
Yes.
Okay.
All right,
You're excused, thank you. Thank you for your testimony.
come on through here. We don't have to worry about the courts.
You may call your next witness.
The defense calls.
Troy Harper.
Stand around here, raise your right hand, face the clerk, or take you.
You do solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Now, sir, if you would have a seat, red chairs, and I'll put a voice in the court. You can go up close to the mic.
Good afternoon. Could you tell the jury your name again, please?
I'm Officer Troy Harper with the St. Petersburg Police Department.
And how long did you say you'd worked for him?
A little over 18 years.
Back in 2015, you were a detective.
Correct, yes.
And had been assigned to work on the case that Detective Miller was the lead investigator, and it involved a suspect named John Jonchuck.
That's correct.
As part of that investigation, were you alerted to a tip from a outside source regarding a traffic incident in Tampa?
Yes, I was.
Tell me, how does that information get to you?
Normally with cases like this, we'll receive numerous tips. Those get filtered through. Our supervisor will assign them out on who's responsible for following up on what tips.
Okay. So the person didn't call you directly?
Not me directly, no.
They would call the police department in general?
That's correct.
And then you somehow got that information?
Yes.
How did you follow up on that information?
There was a contact phone number for the person that had the information, and I called her back later that morning.
Okay. And she gave you some information?
That's correct, yes.
Did it involve something that occurred in the very late hours of January 7th, 2015?
Yes.
And did it involve a white PT Cruiser?
Yes.
After hearing that information, did you think it had some relevance to the case?
Possibly, yes.
was there something you thought that you could possibly do to try to verify or further develop that information?
Well, she provided us with a location for where this incident occurred, that being the intersection of West Kennedy Boulevard and West Shore Boulevard in Tampa. I verified that that intersection is monitored by red light cameras, so we followed up on that lead then.
So you developed the information that the intersection has a red light camera?
Correct.
All right. And then what steps did you take after that?
One of the other detectives assigned to our unit, Detective Tolley, took that information and followed up with the Tampa Police Department and tried to obtain the video.
Now, do you know whether he was able to do that or not?
I do not.
Okay. Because would it have come back to you, or if he did, what would he have done?
It would have, that information would have been forwarded to Detective Miller since he was the lead detective.
Okay. Is that that wasn't the only involvement you had in the case, was it?
No.
The same day that you got that information, did you go to Hillsborough County?
Yes.
Who were you going to Hillsborough County to see?
Responded to Hillsborough County with Detective Miller to make contact with numerous family members of both the suspect, John Jonchuck, and the deceased, Phoebe Jonchuck.
All right. And again, I'm not asking you to tell us what those people told you, but did you make contact with Michelle Kerr?
Yes, Detective Miller and I did, yes.
Okay. Do you happen to remember when you got to Michelle Kerr, had the media already interviewed her?
They were there when we arrived and were packing up and leaving.
Did you also speak to a Brian Morris?
I did, yes.
In discussing the case with Mr. Morris, did he tell you that he had any type of evidence or anything that was important to this case?
He had mentioned that he had several text messages that he had received from Mr. Jonchuck. At the time, he didn't know if they were relevant to the case or not, and he shared those text messages with me.
And when you say text messages, just so we're clear, he's talking about a message that he received on his cell phone?
Correct.
So it would be the cell phone of Brian Morris?
That's correct.
And Brian Morris was the person that described, and he was the person that showed you the cell phone?
Yes.
Okay. And did you see those text messages?
I did, yes.
Did he tell you who the text messages came from?
He told me they came.
Objection, this is hearsay.
Counsel approach.
Detective, just as an aside, you have your report with you, I'm sure?
Yes.
Okay. And I think we clarified that you were speaking to Brian Morris.
Correct.
And he told you that his cell phone had received some text messages.
Correct.
You looked at, were you able to view those text messages?
Yes.
Okay. Did the text messages have a corresponding number from the phone that they were sent from?
The number was not visible, but the name Johnny was attached to the text message thread.
Brian Morris clear up for you who Johnny was?
Yes, we later found out what the number was, and it was confirmed to be a number belonging to Mr. Jonchuck.
So tell me, he's got the cell phone, he's got the text messages there. What do you do?
I read through them with him, like he scrolled through the list of messages. It encompassed messages over the course of 3 days. After I viewed the messages, I had him send screenshots to me on my work phone.
So you reviewed the text messages. Were you able to note the date that the text messages were sent?
Yes.
What was the date of the first text message?
The first text message thread was received on Saturday, January 3rd, 2015.
Could you please tell the jury what that text message said?
We will renew our objection, Mrs. Hearsay.
Thank you.
The first message was from Mr. Jonchuck to Mr. Morris, and it read, "Can you all meet at my mom's? There is Chinese drywall stuff and food that is canned has been spoiled that is still good for 2 years." The next message again from Mr. Jonchuck read, "I think it has been making her and the baby sick." Mr. Jonchuck then sent a photo of an empty bowl.
And let me stop you for a second. Just tell the jury, here we're going from words to a picture, so can you describe for the jury what that picture is that you saw?
It was a photo of what would appear to be an empty, like, cereal type of bowl.
Any cap, any notations?
No, just the photo.
Of an empty bowl?
Correct.
What was the next test message? Sorry.
The next message that Mr. sent read, "I started pulling out to dry and get her organized trees, and that is what I found, and the canned fruits have been like rotten eggs." At that point, Mr. Morris responded back, "Who is this?" And Mr. Jonchuck responded, "This is Johnny. She is really concerned, uncles."
Judge, if I could have a moment?
Sure.
Thank you for coming back in, I appreciate it.
No problem.
Croft?
There you go.
Can Officer Harper be excused?
Yes, Judge?
State?
We'd have to stand by.
Okay, you're still on standby. Thank you,
Thank you,
Officer.
ma'am.
Are you ready with the next witness?
Yes, Judge.
Okay.
Judge, the defense called John Jonchuck Sr.
And sir, if you would step right over here for me, please. Sir, stand right here. Raise your right hand. Ready to take the oath.
Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. And now, sir, if you would step over here for me, please. Take a seat in this red chair. Make sure you speak with a loud and clear voice and slide up close to that mic, all right?
Yes, sir.
Good afternoon, Mr. Jonchuck.
Good afternoon.
Can you tell us your name, please?
John Jonchuck Sr.
What is your son's name?
John Jonchuck Jr.
Do you ever go by the name Doug?
No.
Do you know anyone named, well, I'm sure you do, but is there anyone in your family named Doug?
On his mother's side, there is a Doug Kersey.
And do you know, as far as his mom goes, do you know anything else, whether that would be like a brother or
like a cousin.
Father, cousin?
I want to say it's a cousin.
All right, so then John Jr. has a cousin named Doug.
Yes.
You mentioned the name Michelle. Who is Michelle? Well, I'm sorry, there are more than, is there more than one Michelle involved in this case?
Yes.
What was Phoebe's mother's name?
Michelle Kerr.
John Jonchuck Jr., what was his mother's name?
Michelle Jonchuck.
And John also had a stepmom growing up, did he not?
Yes.
What was her name?
Michelle. We called her Mickey.
Okay. So, were you married to John's mother?
Yes.
Briefly?
Yes.
Okay. And you were also married to Mickey?
Yes.
All right. So if I refer to one as Michelle and the other as Mickey, will that help keep them separate?
Yes.
Thank you. Do you know about when you met Michelle Jonchuck?
Probably in, I want to say around 87, I guess.
Okay. Were you guys, did you guys get married?
Not right away.
Okay. How long were you married, do you think?
I think I married her in 89, right before she had the baby. And then we got divorced probably 4 years later, but we separated after 2.
Okay. So you married Michelle when either before or when she was pregnant with
right
Johnny?
Before he was, excuse me, right before he was born, I married her. That would be in 89.
Okay. When Michelle was pregnant with Johnny, was she using drugs?
Not to my knowledge, but then afterwards, I realized that it was possible.
Okay. So at the time you didn't know?
Right.
But now do you believe that she was?
I believe she could have been.
Okay. You said that you split up with her. About how old was Johnny when you split up?
When I know I said I had him at 2, but when we split up, he was about 2.
Okay.
So,
why did you and Michelle split up?
because she spent all my money.
On what?
Drugs.
How was she using those drugs?
Probably crack, needles, you know, I mean.
Intravenous drug use?
Yeah.
Can we approach?
Yes.
Mr. Jonchuck, you became aware of her intravenous drug use when Johnny was about 2?
Yes,
And that's what caused you guys to go your separate ways?
yes.
Okay. When you initially split, did she keep Johnny or did you have Johnny?
She kept Johnny.
Did you, at that point, not immediately, but at some point in the future, move to another area?
I was working out of town at the time.
And where were you working?
In Nashville, Tennessee.
Sorry to go back, but after you and Michelle split, you guys get along?
Never really communicated as far as if I wanted to see him or not.
Okay. Did there come a time when, while you were in Nashville, that you saw Michelle?
Yeah, she brought me Johnny and dropped him off to me.
And where did she go?
I couldn't tell you.
Did she stay in Nashville with you?
Nope.
Did she call you and tell you she was coming?
To the best of my recollection, I don't think so. I talked to her grandparents. They said she needed help taking care of Johnny. Next thing I knew, she showed up and gave me Johnny.
Okay. You were in Nashville for a while. How long do you think you were in Nashville?
Probably 6 to 8 months.
Where'd you go from there?
From there, might have went to Atlanta and then back to Tampa.
Tampa's your home base anyways?
Yes.
Okay. When you got back to Tampa, did you meet Mickey?
I didn't meet her for a while. It was just me. I met her on a job I did at Tampa General Hospital, a parking deck. I got a job working for Hennessy. Because in my line of work, sometimes you don't stay with the same company if they don't have a lot of work.
Hennessy's a construction company?
Yes.
They do a lot of...
It's concrete form work.
Right, thank you. Now, after Michelle dropped him off in Nashville, did she have any role in helping you raise Johnny at all?
No.
How about, now we're still talking about Johnny's young, I guess at this point he's about what, 3, 4, 5, something?
He's about 4. When I first got him, he was 4. I said he was 2 in a deposition. I'm going to correct that and say he was about 4 years old.
That's fine. Who's Uncle Brian?
Uncle Brian is his mother's brother.
Okay. Now, when he was that 4, 5, and 6, did he ever live with Uncle Brian?
He'd go visit.
For
a night or 2.
Didn't stay for months at a time?
Not at that time, no.
Okay, and this we're talking about now when he was just real young?
Yeah.
Okay. And then I jumped back. I think you told me you met Mickey at a job?
Yes.
Did you guys ever get married?
Yes, we did. It was probably 94, 95 when we got married, April 30th.
And I don't know any other way to say this, sir, but you stayed married to her until she died, right?
Yes.
Did you ever take Johnny when he was young, in those 4, 5, 6 years age, did you ever take him to see a doctor?
Between 5 and 6, after a lot of daycares, he was thrown out of them. One of them said that he needed
Objection
some...
what they said, Judge, of hearsay.
I would think Council approach, please.
Mr. Jonchuck, you took him to the doctor based upon what the daycare told you?
He said he needed help.
Sir. Yes.
Yes.
Thank you. Go, please proceed.
Where was that? Where'd you take him?
Took him to USF Psychological Center there.
All right, and I know and you know what we're talking about here, but just so we're clear, you're talking about the University of South Florida?
Yes.
Okay. And he saw a doctor there?
Yes.
Who took him?
Me and Mickey.
Uncle Brian ever take him?
No.
At this point, where is Michelle Jonchuck?
Good question. Possibly incarcerated.
When Judge Beck, I have just a moment.
Yes.
Mr. Jonchuck, there's water and a cup there if you need it. Just let us know. When Johnny was growing up, were there times that Michelle Jonchuck would say she was coming to get him?
Yes.
Would she show up?
A lot of times, no. Most of the time, actually, no.
When Johnny was young and living with you and Mickey, were you a regular churchgoer?
No.
As Johnny got older, do you know of any time that he became a regular churchgoer?
No.
Do you have any idea how old he was when he met Michelle Kerr?
He was, well, I know at least 18. Now, if he met her before that, I wasn't aware of that.
Okay. And you have met Michelle Kerr on occasion?
On occasion, yes.
I hate to pin you down, but can you give me an idea how many times?
Probably, I'll just say between 10. I'll just say 10. I can't really recall a certain amount of times.
And we think we cleared this up. Michelle Kerr, that's Phoebe's mom?
Yes.
And how did you find out that Michelle was pregnant?
Excuse me. He told us, John.
Were you surprised?
Kinda, yes.
Okay. Did he seem happy?
Yes.
Was he excited?
Sure.
At the time from when Phoebe was born, and I assume even up to today, you've been working?
Yes.
Same kind of work?
Yes.
Okay. And when Johnny was growing up and Mickey was also working?
Yes.
Full-time job?
Yes.
Not like a 9-to-5 job?
Yes.
Once Phoebe was born, did you see Phoebe and Johnny and Michelle Kerr together?
Yes.
Okay. When Phoebe was born, were they living with you?
No.
Some point in time, did John seem to have Phoebe more than Michelle Kerr?
Yes.
John had Phoebe all the time?
Yes.
When that happened, did John and Phoebe ever live with you?
Yes.
And have you been at your same location, your same residence? You've had that for a long time?
Yes.
How many bedrooms in the house?
2.
Did Phoebe have her own room there?
Yes.
Now, when John and Phoebe lived with you, did you get to see him raise Phoebe?
He didn't live with us long. It was in and out. It was periodically.
When he lived with you, let me make sure I got it. When he lived with you, did Phoebe also live with you?
Yes.
Did you ever see John hurt her in any way?
No.
John love her?
Yes.
She love him?
Yes.
Going back to something you said, that he didn't always live with you, were there times when, to your knowledge, that John and Phoebe stayed with Michelle Jonchuck?
Yes.
Forgot to ask you something. Back before John met Michelle Kerr, was John ever Baker acted?
Yeah, a few times.
Do you know how many?
I want to say between 3 and 5.
Did you ever have him Baker acted?
Yes.
Did he ever have himself Baker acted?
I want to say he did, to the best of my recollection.
Mr. Jonchuck, I want to ask you some questions about couple months before this all happened. Had Johnny and Phoebe been living with you?
I want to say they were back and forth between me and his mother.
Were you, and back and forth between, so Johnny and Phoebe, when
Now, excuse me, let me correct that. There was another place that he lived, too. Him and Phoebe lived with some of his friends. I can't give you the exact street name on that.
That's fine. But in the months before, he was living sometimes with you and sometimes with his mom?
Yes.
And then there's some period where you think he was living with a friend?
Yes. Probably before, a couple months before this all happened, he was living with friends.
Okay. And in the weeks before this happened, it was between you and Michelle Jonchuck?
Yes.
Are you aware of her setup, whether she had a house or an apartment or anything?
To my knowledge, she had an apartment.
Do you have any knowledge as to whether it was a one-bedroom or a two-bedroom?
I know at one point she did have a two-bedroom, and then she moved, and she might have moved into a one-bedroom.
Okay. Now, your wife, Mickey, do you know whether she spoke Swedish?
Not to my knowledge.
But do you think she had Swedish background?
Yes.
Did she have a old Bible?
Yes.
Had it been in her family for a long time?
Yes.
You got even any guess as to how long?
No, but long. That was passed down through the family.
4 generations?
Yes.
Okay. Did John, when he was a child, did he have any interest in that Bible?
When he was a child, no.
In the last, in December of 2014, did he develop an interest in that Bible?
214, probably near the end of 214, I guess he had saw it and asked Mickey. Actually, it was around probably right after Christmas or so.
Right after Christmas of 2014?
Roughly, yes.
Okay. Did he ask Mickey if he could have it?
Not have it, but she said he could hold on to it. He wanted to hang on to it, he said.
And did he hang on to it?
Oh, yes.
Did he ever give it back?
No.
Did you ask him to give it back?
Yes.
And when you say hang on to it, do you mean he would carry it with him?
Yeah, he carried it a little bit, but then if he couldn't carry it in his car. I mean, I'm sure it sat in his car, but he didn't have it. I want to say he didn't have it constantly, but.
Did Did he ever tell you that he talked to a priest?
Not to my knowledge. I think I heard about that.
Objection, Judge.
When he was living with you in around Christmas time, did John pour salt around the house?
Yes.
Did he pour salt around the windows?
Yes.
Did he pour salt around the door to Phoebe's bedroom?
I don't know about that.
Did he tell you what the salt was for?
Objection, Judge. Just
Mr. Jonchuck, jumping back to something I asked you earlier, you said that you took him to USF to see a doctor?
Yes.
And that was around between, was it 4 and 6 years of age that he was doing that?
Probably 5 and 6.
5 and 6. And they prescribed him medication?
After a while, first he was getting some counseling. They talked to me and Nick, and they take him in and talk to him. And then eventually they said,
objection, what they said,
they diagnosed.
Whoa. Okay, you can't talk about it.
That's fine. Mr. Jonchuck, let me ask you this question. And I just kind of want to get the years and stuff down. You were taking him to USF till from about 5 or 6 years old?
Yes.
And then he continued to go to USF till he was about 12 or 14?
I'm not sure it was that long.
But it was a long time?
No, once he got on the medicine, he started school. And then it would, if he went there, it was just for them to check on him every so often. It wasn't like he kept going. Once they diagnosed him.
You can't tell us that, okay?
Okay.
Thank you.
All right.
But he was taking medicine from that point on?
Yes.
Okay. All right, and sorry, I jumped away, and I wanted to go back and ask you a little bit before this happened. You said that John poured salt around the house and the windows?
I was unaware of that at the time until I happened to be looking out one of my windows one day, and I asked about that.
Okay.
Because I didn't get to elaborate it on it when you asked me the question.
Yeah, and I'm gonna ask you again, did he tell you why he put the salt there?
Apparently, it's to keep out evil spirits.
The night that this happened, Johnny and Phoebe were at your house earlier in the night?
Yes.
You and Mickey were there?
Yes.
And Johnny and Phoebe were there, you guys had dinner?
Yes.
Remember what you had?
Yes.
What was it?
Scrambled eggs and sausage. We had breakfast for dinner.
Sometime after that, did Michelle Jonchuck come over?
She was there.
Okay, so she was there for dinner also?
Yes.
Okay. Did you have any reason to think that John had been drinking or doing drugs that night?
No.
I'll have your
Cross.
You worked a lot when the defendant was a child, right?
Yes.
And worked long hours.
Yes.
You tried to instill that into the defendant? That work ethic?
Yes.
Did he have that work ethic?
No.
Did he have lots of jobs?
Yes.
Did he stay on them very long?
No.
Did he go from place to place to stay with people and live with people?
Well, after him and his girlfriend broke up, apparently. First they were together for a while after the baby.
And when did he leave your house? When he, at what age did he leave?
18.
Why?
Because he damaged my house, scared my wife, and I threw him out.
What do you mean damaged your house?
He broke a lot of stuff in my house.
So bad you had to clean it up with a shovel and a
Yes.
big trash can?
Yes.
When he gets angry, he destroys things, right?
Objection, relevance, and can be approached.
Yes.
Michelle, the defendant's biological mom, she wasn't in his life when he was early in his life, correct?
Up until she gave him to me.
I mean, after that.
No.
But she then got more into his life after Phoebe was born.
Yes.
So much so that he and Phoebe sometimes stayed with Michelle.
Yes.
As a matter of fact, there were times when Phoebe would be with Michelle and the defendant would be living somewhere else or staying somewhere else.
Yes.
Same with you. Did you ever watch Phoebe just by yourself? You and Mickey?
I think we babysat once or twice for a few hours.
Okay. And you said that the couple months prior to the murder, he was staying between you, he and Phoebe were staying with you and Mickey, and then sometimes with Michelle?
Yes.
Back and forth?
Yes.
And you really didn't see a shift in his change in his behavior during that time, did you?
No.
Okay. So that's for a 2-month period, he was basically the same?
Yes.
When was the last time you saw him on January 7th? Do you know what the time was?
That night, I mean, this happened on the 8th, correct?
Right, you had dinner, you had the sausage and eggs?
Yes.
Did you go to bed?
Yes.
What time?
We all went to bed, I want to say between 10 and 10:30.
Okay. You think that Phoebe and the defendant were still there at 10 or 10:30?
Yes.
Okay.
As far as I know, I want to say to the best of my recollection.
Okay, that's all we can ask.
Okay.
Did you hear them leave?
No.
When you woke up the next morning, were you surprised they were not there?
Yes, kind of.
At that point, you did not know where he had gone or what he had done?
No.
And during that last couple months that you saw him, he hadn't changed his behavior. He was acting like John.
Pretty much.
Pretty normal.
Yes.
Nothing further judgment.
Redirect.
Nothing further, Your Honor.
Okay. Mr. Jonchuck be excused, or is he on standby?
Excuse,
We'd like to leave you on standby, please.
Mr. Jonchuck, you're excused for now, but you're on standby. Do you know what that means?
Do I stay here for the rest of the day or the rest
No.
of the trial?
I have no idea how long the trial will last, but you have to be available to come back. You live in Tampa?
Yes.
So you have to be,
Okay.
close to the county and be available to come back if needed.
Yes.
And someone has a way to get a hold of you, correct?
Yes.
Okay, thank you for your testimony. All right, sir. Oh, thank you. Jury questions, Mr. Jonchuck. Oh, excellent. Can you sit back down, please? Pardon?
I don't know if they can be answered though.
Well, we decide, but you get to ask whatever question you want. Counsel, approach, please. What dates he was Baker acted in the past, or what the reasons were, correct? Okay, Mr. Jonchuck, you can answer that if you can. I don't know if you can. You want me to read it again?
No.
Okay.
I can't be specific, actually. I mean, once I Baker acted him, I couldn't even give you the date to that, but that was because he attacked me. Okay? And I had him Baker acted. Another time, I think they Baker acted him because he stabbed himself, okay, in the arm. And then another time, I know he had himself Baker acted, probably due to, because he was going to get arrested or in trouble, to the best of my knowledge. And the other couple of times, I'm not sure at all.
Okay. Does that answer your question? Okay. Any other questions of Mr. Jonchuck? No, ma'am. No? All right, thank you. Thank you,
Judge,
sir.
can we have
Yeah.
one moment?
Yeah. Do you have any follow-up questions while they're pausing?
Not this point.
No further questions, Judge.
Okay, so you're on standby? Thank you very much.
That's it.
Anybody else? Ms. McNeil? Yes, sir. Are you all finished? Oh, okay, you can call your next witness. Do you need a break? Anybody need a break? Are you good? Good? Okay, call your next witness.
That's the defense calls Tara Hernandez Velez.
Hey, ma'am, you would step over here for me, please? You just stand right here. you go. Please, this clerk. Raise your right hand. Prepare to take the oath.
You do solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And now, ma'am, if you would, have a seat in the red chair. Speak in a loud and clear voice for the court. Make sure you move up close to the mic.
Thank you.
Good afternoon, what's the name again?
Let me check and make sure I got it right. Tara, is it still Hernandez?
No, sir.
Okay, so we get rid of the Hernandez and go with the Velez, V-E-L-E-Z?
Yes, sir.
Good afternoon, Ms. Velez.
Good afternoon.
Tell us your name, please.
Tara Velez.
All right. Perhaps we should give a little background here. Did your name used to have Hernandez in it?
Yes, it was Tara Hernandez. It's now Tara Velez.
Okay. And I assume that has something to do with whether you're married or not married now?
Correct.
Okay. We don't need to know. But just a little bit of background. How old are you, ma'am?
41, sir.
And where do you live?
South Tampa.
Just South Tampa?
Yes.
Okay. Have you lived in South Tampa or have you lived in Tampa for a long time?
Yes, I've been in South Tampa for over 25 years now.
Okay. And were you living in South Tampa? Well, just give us an idea of what kind of work you do.
Right now, I'm a property manager.
Okay. Were you living in South Tampa back on January 7th of 2015?
Yes, sir.
You have been listed as a witness in the case of the state of Florida versus John Jonchuck Jr. Do you understand that you have some information in that case?
Yes, sir.
Okay. How, do you know how your information or how your name became available to the, well, did you talk to the police about this case?
I did.
And do you know how your name became available to the police?
Yes.
And how was that?
I was the one who called the detective.
Okay. So, I don't know if that's the right word, but you called in a tip.
I called the police, yes.
Okay. And it wasn't somebody didn't pull your name or somebody, it wasn't somehow, somebody, they got your name somehow and you contacted them?
I did.
All right. And when did you do that?
The next morning.
Early on January 8th?
Yes, as soon as I got into work, which would have been in the 8 to 8:30ish range in the
Okay.
AM.
And when you got to work, did you learn something had happened?
Yes.
And what did you learn had happened?
As soon as I walked into work, one of my coworkers went ahead and told me, "Did you hear what happened on the news?" And I said, "No, I didn't." And I asked her what it was, and she told me.
Objection, Judge Hearsay.
What I can't do is ask you what someone else said.
Okay, I was getting to it.
It's all right. You heard that something horrible had happened the night before.
And I went ahead and I looked on the news on my computer.
And what did you do after that?
I went ahead and I called 911.
Okay. Did someone come out to talk to you immediately, or was it a little bit later?
No, I was in contact with them, told them what I knew, what I seen, and then afterwards, I received notice to go down to the state attorney's office.
Okay. So you're, just so I know what make sure I'm right on this, when you decided to make your report, you called 911?
I believe so, yes.
As opposed to like calling the St. Pete Police Department or the Hillsborough County Sheriff's Office. I mean, number you went to is 911?
I believe so.
They took some information from you?
I went ahead and I told them what I had to say, what I seen, and what I saw on the news. And then they went ahead and I think they gave me the number or to the, well, sorry, it was a long time ago. They possibly gave me the number to the police department itself to call, to leave a message for the detective on the case.
All right. Do you remember if the detective came out and talked to you in person, or did you talk to him on the telephone?
No, I believe I spoke to them over the phone.
Okay. And your conversation, the person you saw on the news, was that the person that you had seen the night before?
Yes, sir.
All right. And that's how you knew something, that's how you knew that you had some information about what had happened on the bridge?
Yes.
All right. So tell me a little bit about that. Back in January 7th of 2015, you were living in an apartment complex?
Yes.
Okay. Did you know your neighbors?
Not throughout the whole complex, sir, no.
Did you know anyone at that time named Noemi Bresnahan?
No.
Back on January 7th of 2015, we know you were living at that apartment complex. In the evening hours, had you been out? Did you go somewhere?
Yes.
Where'd you go?
I went to Starbucks.
Okay. Was anybody with you?
Yes, I had a friend with me.
And when you get it to go?
Yes, we got coffee to go and then headed back.
Okay. Coming back, where did you go?
We went back to the apartment community.
Okay. Go into your apartment?
No.
Where did you go? Where'd you stay?
The apartment, my staircase was here. The parking spaces were right, probably about not even 10 feet from the staircase to my apartment. And I parked over to the side where it had a little grass space by the fence line.
Okay. Anything you can remember about the weather that night?
It was very cool.
Okay. That stairway that you talked about, anything special about that staircase?
Yes, it goes only to my apartment.
Nobody else's?
No.
Driver or passenger?
I was the passenger.
Okay. When you parked the car, did you get out of the car or did you stay in the car?
We stayed in the car.
What were you doing?
We were talking.
Okay. And drinking your coffee?
Yes.
Okay. There anything unusual about that? I mean, there was no, that was just the plan, to go get coffee and talk for a while?
Correct.
Okay. What did you see?
I seen a man walking with a little girl pacing back and forth in front of my staircase.
All right, let me stop you for a second there. Did that concern you?
Yes.
Why?
Because I'm a mom. It was really cold out. It was late at night, and the little girl didn't have what should have been on her to be out in the cold.
Okay. So we got that concern. Was there another concern as well?
I hadn't seen the person there before in my comings and goings of the apartment community, and he looked lost.
Did that staircase have any, contribute in any way to your concern?
Correct, because it was the staircase that led to my apartment door, and that's where it was, the pacing was happening.
Okay. pacing back and forth?
Yes.
Okay. Little girl, was there a little girl with him?
Yes.
Okay, I know I'm going over this, but I gotta make sure we get it all out there. Were they, what could you tell us about, as far as the guy pacing back and forth, the little girl being there? Was he holding her, carrying her, walking her? Tell me what you saw.
Holding her hand.
Okay. Was she walking with him as they went back and
Yes.
forth? All right. Do you remember what she was wearing?
Shorts. It looked like a light, very, very thin sweater, and socks.
Shoes?
No shoes.
I don't need a full description, but were you dressed appropriately for that weather?
Yes.
What were you wearing?
I had on pants and a shirt, but I was in the car with the heater on, so.
Okay. How long do you think you saw this happen?
It couldn't have been more than 5 minutes.
Pacing back and forth the whole time?
Yes.
Ever stop?
No.
You ever see him knock on a door or anything?
No.
You ever hear him call out or anything?
No.
You mentioned you're a mom, right?
Yes.
All right. What did your maternal instincts tell you?
Something wasn't right.
Did you mention that to the person you were with?
Yes.
You mentioned you're in the parking lot of the apartment complex. Street lights?
Yes.
Well lit?
Very.
You able to see the person's face?
Yes.
Can you describe to the jury what he looked like, or what kind of expression was on his face?
He looked like somebody who had a lot on their mind, but probably like a lot of thoughts just lost.
Of like a clueless look?
Kind of clueless, yes, I would say.
And you had a chance to talk to people about this case before. Anything else you could tell us about that look? Like he was he in the here and now, or did it look like he just was not all there?
Should've just been asked and answered.
On those grounds overall.
I would say that he had the look on his face of somebody who had.
Just object to speculation.
Try something else.
Lack of foundation as well.
No. Go ahead. Go ahead.
You can tell us what you saw.
I don't, okay.
And if you've told us all you can tell us, that you can just tell us, I don't know anymore.
No, he looked like somebody who had 1,000 thoughts running through their head. Just didn't know where to start, just lost.
Thank you. And how far away was he?
Probably about 15 feet, maybe 20 feet, no more than that.
This far?
I would probably say more so along the lines of where the gentleman is and the tie right there. About that far, yes.
Want him to stand up?
If you wanted to, yeah.
About that far?
He was about that far.
Okay. And it's well lit?
Yes.
Thank you.
Judge, for the record, I would
Yeah.
Yes, it's about 35 to 40 feet.
Okay, 35 or 40 feet.
Do you have any difficulty seeing him?
No.
It was clear, you could clearly see him?
Yes.
Judge, if I could have a moment.
Sure.
Judge, may we approach?
Yes.
Just a couple of things I wanted to ask you. When you went to Starbucks, do you know about what time it was?
I want to say it was probably between 10 and 11.
Okay, and are you sure, or do you just guessing, or do you know?
No, I'm not guessing. I know it was between that time, more or less. I'm trying to say that more if you want specifics, maybe 10:45-ish, maybe a little bit before.
Okay, that's fine.
Okay.
Now let me ask you a question. Do you live in the same place as where this happened?
No, sir.
Okay. Tell us, with as best you can where this happened. If you know the address, that's great. If you know the name of the apartment complex, that's great. Tell us everything you can.
The name of the apartment community is Oakwood Apartments. It's in South Tampa on Del Mabry South and Iowa.
Okay. Tell me a little bit about the apartment complex. Is it separate buildings?
Yes.
So did your building have a name or a number?
It was, I can give you the address. I don't remember if there was any numbers on the building itself, but it was 5901 apartment D.
Okay. I just wanted to clear up one thing. You advised us that you saw the person from the distance of where you're sitting to where the man in the tie is, correct?
Just about.
Okay. It was not your testimony that that is 35 or 40 feet. But you are saying that is about the distance.
I'm saying that's about the distance. To me, in my mind, it was probably about 20 feet, so I apologize.
No, that's fine. I just want to make sure that we know what you said. All right. Did you mention to your friend while this was going on that something seemed weird, right?
Yes.
Okay. Did you see the man and the little girl get into a car?
Yes.
Did you see them drive off?
Yes.
Okay. And is that the last you saw?
Yes.
That's all I have, Judge.
Ross, do you need a break? Do you all want a break before cross? No? Okay.
You were the passenger in the car?
Yes, sir.
Who was your friend?
I'm sorry? The
Who's your
name?
friend? Yes.
Herbert Ordonez.
Okay. This all took about 3 to 5 minutes, right?
Yes.
Okay. And you said this was about 10 or 11 at night?
Yes.
You didn't see him on the phone?
No.
Didn't see him with the phone?
No.
Okay. And when he left, he put the child in the back seat?
I don't know. I don't remember where in the car the child was put.
Do you remember giving a deposition in this case?
Yes.
And would referring to that deposition help you recall what you said?
It was a long time ago, so possibly.
May I approach the witness? Looking at page 6, from 19 to 25. May I approach it? If you would read to yourself lines 19 to 25.
Okay.
Does that help you remember?
Well, it does not help me remember.
Okay.
But I did say in the statement, I believe.
Put it in the back seat.
Yes.
And then drove off. You don't know which direction?
After they get out of the community or the complex, no, but I know that they have to drive the way out. It's only one way in, one way out, really.
Okay. So it was as if he would have to known somebody in that area to get back to where you were?
No, at the time,
Sustained.
Nothing further, Judge.
Anything further?
Go, Your Honor.
Okay. Can Ms. Velez be excused? Stand by.
She can be excused, Judge.
Excuse, Judge.
Okay, thank you for
Thank
your
you.
testimony. You're excused. glad or sad, doesn't really matter. So we'll start tomorrow morning at 9 and plan to take it till 6. Okay? Thank you. Any questions at all? Leave the hats on the chairs.
We're gonna try and move that into the back room.
You're gonna do what?
We're gonna try and move that TV, put it into the back room if that's all right.
Sure.
Just try to get it out of everybody's way. I know it's
Sure.
not convenient.
Come all the way around, Council. You did say the jury is hearing in court, didn't
No,
I?
but
Didn't? I didn't.
I may not have heard it, because very well said it. So you don't know whether you said it, and I don't know whether I heard it.
I heard it now.
We're waiting. Do you have something you want to bring up?
Yes.
We're waiting on this man out to the bathroom.
Oh. Judge, I can start. 'Cause
Okay.
We have no issues as far as we know. Judge, tomorrow we have four, well, actually, now we're down to 3 in the morning because we just called in Hernandez early. We have the attorney. We are trying to get Father Bill Swengros. And then Valerie Mallory, who is a witness at another one of the churches that he went to. So we have those 3 people. I've spoken personally to Genevieve Torres, so we know we have her first thing in the morning.
Is she coming at 9 o'clock? Is she your first witness?
I think I asked her to come at 9, yes, Judge.
Okay.
I'll be texting her tonight to tell
All
her
right.
that's the appropriate time. We believe that Michelle Jonchuck, she was sick today, so that's why we couldn't bring her in. We can use her tomorrow at any time.
Well, she has court
Well,
at 9 after court.
She has court in Tampa, so we can't, after she's done from court, she can't come here.
Okay.
As far as tomorrow afternoon, we have Dr. Hernandez, the treating psychiatrist from the Pinellas County Jail. We've asked our witnesses from Gainesville to drive down tomorrow morning so that they can be here. And we hope to talk to them at lunchtime, and we would then be calling 2 doctors and his forensic case manager, Heather Davis. So we have lined up for Thursday afternoon. Judge, we also have Dr. Mackless is one of our expert witnesses. We have him lined up for Friday. I suspect his testimony will be lengthy. I assume the cross-examination will be lengthy. The issue we have is Dr. Otto and Dr. Mayer have both advised us that they are not available on Friday or Monday.
Thank you for telling me. Why?
Well, Mayor is out of town, Otto has class, and based on the court previously saying we weren't gonna do Mondays, that's what I advised him, and so his class, he did not get covered.
He has class on Monday?
He teaches, right.
Right. Do you think you could get coverage and come in Monday morning?
He said he is not available on Monday. Well, I don't think he would just be a Monday morning. His direct is going to be very lengthy. I don't know, I assume his cross would be as well, but I don't see him being a half-day witness.
Who's coming on Friday?
Mackless.
And that's it? That's the only witness you have for Friday?
Because Otto and Mayor are both unavailable Friday, Monday.
Unless we don't get through.
Right, and
everybody
unless we don't get
tomorrow.
Okay, wow. All right, so then Tuesday is Otto.
Right.
And then what would be left?
Just Mayor.
He would be Tuesday too.
Depending on how long Otto lasts, he's available starting Tuesday.
Okay, so the defense will possibly finish up their case on Tuesday. That would be an accurate statement.
Possibly, and for sure on Wednesday.
For sure Wednesday.
Okay. So that gives you all some kind of guideline. All right. So I should probably do my own pre-trials, all depending. Right?
We were under that belief, that's
Well,
why.
so was I.
Right, that's the only reason
So
that we.
till I got a volunteer, so.
Take advantage of that.
You never know when you might have to cash it in later.
Fair.
So I could have the jury come back Monday afternoon to hear the rest of something if necessary. If not, they'd have Monday off. Okay.
Judge, and I want to clarify the court's ruling. Dr. Lazaro is going to be able to sit in through the testimony of Genevieve Torres.
Yes.
We don't have that luxury, obviously, so are we allowed to use our camera to record her testimony so that our experts can review it, have the same access to her testimony that the state's experts do?
Let me just put it this way. From powers higher than myself, I have received some negative perspective on all that. And I'm going to respect that, and we're done with that.
With what?
Recording stuff in the courtroom. Is that what you're talking about?
Yes, ma'am.
Then I think we have an issue.
What issue?
We had discussed moving to exclude experts from the courtroom altogether due to the great expense that it would cost the taxpayers of Pinellas County to pay for 5 doctors to sit through days and days and days of testimony between, how many hundreds of dollars an hour? And so we did not make that motion based on the court's ruling that we could videotape, because obviously then if we needed to play something back, that would save the issue of them having to testify.
There are issues involved in that I didn't correctly evaluate.
Could we have some insight?
No.
So the court's just sua sponte changing the
I am.
ruling?
I am.
Maybe we have a moment to discuss, because that's
Yeah, sure.
going to affect some things for us.
Yeah, of course.
Judge, can we go in the back room?
Yeah.
And could Mr. Jonchuck be taken in the back room?
It's up to the deputies. Can you take him to the back room? I guess you can.
Never mind, I'll stay with him. You guys discuss. That's not
Oh,
good.
wait a minute, don't jump the gun. Can you take, Mr. Jonchuck in the back room?
I can. I just
Can.
clear that room.
Yeah, okay. You can go.
I need an available deputy to step in the courtroom too.
We're gonna step outside while they do that, if that's right.
Okay, and I'll step outside.
We're good. Deputy McLean, you wanna stay in the courtroom?
Yes, sir.
Give me a disregard, I got Deputy McLean. Stand by, let me get it set
How long do you
up.
think you're gonna need, so I know?
I don't think that we need to necessarily, but we just didn't want to leave him alone. So he.
Okay, well, how long do you need, so I'll just,
give
for
us
a
a couple
recess
minutes.
to talk about it.
Counsel, do you need him to be part of your discussion?
No, he can just go
And
in
we
that
just-
back room.
All right.
Okay, but how long do you need?
10 minutes probably.
10 minutes, okay, so we'll reconvene in 4:20.
All rise. Court will be in recess for 10 minutes according to the courtroom clock.
Yeah, we'll be back out. Talk to you boys.
Yeah.
So I guess we can't come on Genevieve tomorrow. If our doctors are unavailable to come watch it.
Kevin, want me to secure that we don't have to do it again? You can see the vote. Sorry about that.
Thinking about if we have to bring Heather down twice. That's something for you to phone or something, or Skype.
What do we need to discuss?
Judge, so obviously we were relying on the court's ruling regarding the videotaping. We are uncertain whether we are going to be able to secure the funds for our experts to sit through 2 full days of testimony, or more, right? So I don't know, I guess our thought is, I mean, we're going to be asking the court for time in between Dr. Burston and Dr. Lazaro's direct and cross. The way the technology was set up, we had it so that we could say something in real time. If there was a concern we had about testimony, it would be sent to one of our experts immediately in preparation for cross-examination. Since we'll be unable to do that, we are going to need, between the lawyers, we'll have to go back, find a live feed recording online, which means we'll have to watch it, because of the same monetary issues of having them watch or sit through multiple hours of testimony, we're going to have time to review that ourselves so that we can pull out any issues and have an opportunity to prepare the cross for that.
Okay, I understand, and I did not find out till this morning that I was uncertain of it when I did it. And I knew it was like a maverick thing to do, and it's really not well thought out. And the problem is there's 1 court record. There's not 2 court records or 3 or 4 or 5. Hold on. And you were even asking to use it in closing argument, and that's not going to happen. So I'm not going to do it. I'm not going to invite error from using this procedure.
And we put in the motion and still maintain we would not be in any way trying to introduce it in lieu of the official court record.
Well, it's one thing to say you don't intend to, and then it happens. And you were asking to use it in closing argument, and if that would happen, there would be all sorts of issues about it being a court record, and I'm not supposed to do that, and I'm not going to do it, and I should never have said that. It's a mistake, and I should have checked before I said it.
Right, so if we agree not to use it in closing, can we use it for the experts?
Well, it's not agreeing. I wouldn't like to use it in closing, so you don't have to agree with it.
Oh, I mean, okay. Without objection.
How much extra do they charge for sitting through testimony?
It's the same hourly rate.
That's what they do, they charge the hourly rate for sitting through testimony? Yes?
As far as I know.
Yes, ma'am.
And who do you get that approved by?
Mr. Dillinger?
Okay, I can see how you relied on it, even though I shouldn't have done it. So, yes, you can use it for the experts, but that's it. And it is not appearing anywhere else.
Are we allowed to use it for Ms. Torres?
No.
Okay. So we just need to have her come on a day when our experts are available to watch her.
Well, my understanding is she's testifying tomorrow morning.
Well, that was our plan, but we were planning to record it, so because the experts are sitting in for her testimony, she's the only lay witness. Based on all the reasons the state asked their expert to sit in, we were going to record just hers and send it to ours.
No. You don't have a dog in this fight, right?
Just trying to get a little clarification whenever we're ready.
Torres is not a problem. We got Torres covered.
So she's testifying tomorrow or she's not?
She is, Judge. We'll just order a transcript from the court report.
Or you can get, why not use a digital transcript? It can't be part of the court record, but if there's, if you want to use something, there it is.
I don't think digital does transcripts when we have live court reporter. I think it's either digital or steno. I'm not positive, but.
I'm sure the court reporter can prepare a transcript.
Yeah, but it might be more expensive.
I think they charge the same.
Really?
I guess so.
See?
Can I approach?
Yeah.
I thought you guys were doing that too.
No.
Sure. Do we find out anything, Judge?
I just sent a message to digital.
Okay.
Judge, can I clarify something while we're
Yeah.
right, not to make things more complicated? So Dr. Mercy can't be here tomorrow.
Okay.
Based on your ruling, I would assume you don't have a problem with him watching the live feed of Genevieve Torres' testimony if it's only her testimony.
Well, no, how would
Right.
I stop anybody from watching the live?
Right, I just wanted to make sure.
Well, the rule of sequestration. But that's right.
There's an exception for the Torres.
Right.
Okay.
Well, why don't you have your experts watch the live feed?
It's the time.
It's the same amount of time, unless we can direct them to, the issue with the live feed is it is an available recording. That's what we're saying. We would just need time for us to watch it again, to find the timestamps, so that we can say, watch between this minute and this minute, rather than, I mean, it's the same amount of money if they sit behind a computer and watch 8 hours, or they sit in the courtroom for 8 hours. So the issue is how much of it, whether they have to sit through the whole thing, or if there's something that we think is that we actually need to run by them.
We got this.
Yeah, we can find out later.
Okay.
Get it.
All right.
You don't need to, I mean,
Okay.
we'll figure it
So
out.
is there anything else we need to discuss?
Just one other thing. So going along with your ruling, it would seem to me that they can't produce a transcript of that recording that they produced for their experts and then use it as evidence in court.
No.
Okay.
Okay.
That's all we had.
All right.
Thank you.
You're welcome. Have a good evening. So what's happening tomorrow? 9 o'clock is?
9 o'clock is for us.
Okay.
Yeah, those 7 or 8 or whatever.
Okay. Thank you. Have a good night.
You're in a whole separate matter. I have students who wanted to come. I haven't seen a problem with space here. Do you have any?
Who wants to come?
I have students for my evidence in my criminal law class who wanted to come
As long as
watch.
you're from the courtroom.
So I figured I just want to make sure.
Yeah, there haven't been many people here, so.
Okay.
Okay.
I've done videos, so I'm pretty sure it's the same cost as with it,
Really?
record.
Yeah, I know, but they can use it for impeaching without, they don't, all they need is, did you say this here? They don't need that. Oh, they don't.